Thank you.
Thank you, Chris.
Glad we came early.
Yes, thank you for coming here, and thank you for jumping straight into it.
That's
Probably weren't.
no, that's okay though. It's good to be efficient, Commissioner. We have hard copies. I'm not sure, sorry, of the protocols. Would you like those? Yeah. Yours. So that's summary statement and our legal submission.
Thank you. So just to orientate the panel to the documents before I introduce the team, there's some legal submissions from myself, Josh Leakey, counsel for Doolittle. Mr. McFarlane, who's to my right, has prepared some short talking points, but we thought it'd be helpful to pass those up in writing as well. He can talk to those and take questions, and Mr. Dunn has prepared a summary statement, consultant planner for Doolittle. So I'm conscious of time, and if the panel's minded, I'd propose I just take you to the high points of the submissions. So the appear today for Doolittle, which is essentially Mr. McFarlane, who sits to my right. And Doolittle owns land, as I've described at paragraph 2. It's just over 8,000 square metres. Mr. Doolittle, Mr. McFarlane seeks the land be zoned for a commercial precinct. The council opposes that, but has agreed to the alternative relief of high-density residential, which isn't preferred by Doolittle, but is preferred to the notified version.
Just one thing on that was I'm going to get the word wrong, but Mr. Brown will help me. The idea of the
live work.
Cool. So you're up to speed on that one?
Yes, we've been keeping an eye on that discussion and can talk to that.
Perfect. Lovely.
As we go. So paragraph 6 is really the crux of the Doolittle case, that the use of the site for a local commercial activity for the immediate local catchment is the most appropriate use. And if I could just take the panel to the last page of my submissions, because ultimately a picture speaks 1,000 words in this case, and we've just prepared a visual using the council's sort of indicative structure plan documents, and we've shown the Doolittle land there with a red hatching around the outside. The council's notified and supported commercial area shown in purple, which the panel will be very familiar with now. The country club shown there across the road from the Doolittle site.
Yep. And
immediately across the road is the consented dementia hospital and aged care facility. And then Carlisle Park being whether we call it a local centre, but a commercial area. So fundamentally the case for Doolittle is that this creates a corridor of non-residential activity, and that corridor plays a really important role in linking the existing Lake Hayes Estate and Shotover Country communities, which I understand is about 4,500 residents, to the variation area, which is across the road. And the Doolittle site forms part of that corridor, making it well suited to commercial activity. There was an issue of scope, which I understand has now been resolved, so I don't need to dwell on that. Mr. McFarlane will speak to the Doolittle vision about the sorts of activities that Doolittle would like to see on the site, and I've just broadly summarised those there. One point I haven't put in the vision is there was comments for the council's economists that there is a lack of identified centre within those existing communities, but that ultimately the opportunity has now passed for that to be established. Well, we're here today to say that's the role that Doolittle see their land fulfilling, so providing for those existing communities within a walkable catchment is a big part of the suitability of this site for those activities. Page 4, I've outlined the law, which the panel are very familiar with. I won't go over that. The only sort of submitter-specific point I'd like to make on the law is that the environment against which the panel need to make their determination in my submission does include that existing environment. So those existing communities, it's not just the land subject to the variation. The needs and the need for a well-functioning community includes those existing Lake Hayes Estate and Shireva country communities. And that flows through, and I've just summarised that at page sort of 4 and 5 of my submissions around the design principles about there being connected communities, and also the first upfront objective in the zone is around integration with integration, and it mentions these communities. So that's a big part of the Doolittle case. Paragraph 30, I've introduced this corridor approach, which I've talked to using the visual aids, and I was reviewing Mr. Church's evidence for another submitter, and he talked about a more nuanced hierarchy for commercial activities, and we would share that view, and in that sense, having various commercial areas will better provide for this community, rather than just one commercial heart. Moving to page 8, where we respond to the council's concerns, which I'd broadly summarise as an urban form concern and also an economic demand concern. So the urban form concern is a difference of opinion between whether there is one commercial hut to this area or the Doolittle case is that there is a natural corridor where further commercial activities would be well suited. Paragraphs 45 and 46, I've touched on the evidential crux of that, and in particular the fact that this land will be walkable to those existing communities and also to the new community enabled by the variation. Traffic effects, there hasn't been a lot of focus on that. That Doolittle has commissioned a greenhouse gas assessment, which was attached to Mr. Dunn's evidence, so Mr. Dunn can speak to that. But that did conclude the benefits of this land being used for commercial activity versus not, which is a driver of the variation. But in terms of how I submit transportation matters can be dealt with at this stage, there's the RDA trigger for commercial activity within the precinct that would enable that assessment to be made at the time of consenting. But ultimately, the argument is a relatively logical one, as I put it, 56, that if we put commercial activity on the same side of the road as those existing communities, it's going to better encourage active transport, so walking and biking. Moving to economic demand, Doolittle isn't calling an economist, but so fundamentally we're concerned that there's been a history of demand not keeping up with supply in this district, and that in the 2017 study that's been well litigated through the PDP, there's now a broad acknowledgement, and I think the council's economist has acknowledged this in their evidence, that there just hasn't been sufficient business and residential land. And the takeaway really from that is the risk of oversupplying commercial land in my submission is low in relation to this Doolittle site. And at paragraph 60, I've just given some sort of market analysis. The halfway house, if you like, or the concept of a live-work approach. I've had professional experiences with those live-work complexes on Glendhu Drive and also over in Wanaka, and there's an overwhelming demand for people to be consenting retail activity in them. And in those instances, or in particular in the Wanaka one, it's a prohibited activity to have retail activity in those live-work units. So fundamentally, there's a real demand for that retail activity, and Doolittle is concerned that the live-work unit just won't provide for that demand. And Mr. Dunn has some thoughts as well from a planning perspective of where fundamentally a high-density residential outcome may better provide for that live-work approach as an alternative to the commercial still being much preferred. I've briefly summarised Mr. Dunn's 32AA analysis. I'll let him speak to that at 65. I've just touched on the key points there around this integration and not undermining the centre's hierarchy through the relief sought by Doolittle. I'll just add at 68, in terms of managing risk of acting on the Doolittle submission, one is that there's a tool within the plan already putting a size limit on these commercial activities, so that's going to help ensure that overall centre's hierarchy isn't undermined through the relief sought by Doolittle. What I haven't put in my submissions in writing, but occurred to me this morning, was an additional way that risk of acting on the Doolittle submission can be managed, is that in the event that Mr. McFarlane's wrong and there isn't a demand for commercial, there's still a consenting pathway for residential activity within that commercial precinct. So the land will not sit vacant, there will always be an activity there, and it may become a mixture of both, and that's not a bad thing. For completeness, I've touched on the alternative relief at 69 to 71, not preferred, but if that's where the panel head, the high density is certainly preferred over a low density residential outcome. And it's for similar reasons. It's that corridor, it's well connected, it's well located within the broader Ladies Mile area. And the rest of my submissions just really conclude that. I don't propose to read those out. And I'm happy to take questions now or sort of as a collective as we work through the presentation. Thank you.
Thank you very much. I don't have any specific questions now. I think they'll probably merge as we go through, but just check with the panel whether there's anything specific now. Judith? No. So maybe, is it Mr.
McFarlane? I'll pass to Mr. McFarlane, who's prepared talking points, doesn't propose to read them out unless there's any points in particular, Angus, you'd like to take the panel to. Otherwise you can take questions.
No, I don't think so, and the panel's got the pre-submitted, and if you'd like me to read it out, I'm happy to, but other than that, any of your questions or concerns, I'm happy to address where I can.
Perhaps while the panel's orientating themselves, if you could talk to your paragraph 9 about the sorts of activities you envision for this land.
You've got a short dossier on McFarlane, and my experiences, and I know it's been in Christchurch and not here. We've also done some in Nelson, but here I'm residing here now, and we certainly see a need for localised commercial activity, easy access. We see a mix of office, retail, and possibly some accommodation, but it's generally when you incorporate accommodation into these sorts of developments, we have noise issues and access issues, and we sort of start chasing around after the tenants a little bit. My desire is to develop and own my developments. Unfortunately, in my Christchurch developments, the earthquake came and cleaned them out, and the government took the lot. So my philosophy is one of developing and own where I can, and certainly maintain liquidity and the ability to accommodate tenants and business needs. I see this site as a wonderful site because it's, as Josh has alluded to, it's connected directly with Hayes Creek and more so Hayes Creek with Shotover country, but access, the safety and the demand is terrific, and I see it as an opportunity that shouldn't be missed.
Thank you very much. Questions for Mr. McFarlane? Ian?
No, thank you.
I do have a couple, if that's all right, Mr. McFarlane. We had a bit of a drive around as a panel. Sorry, it helps if I do that, doesn't it? We have had a bit of a drive around as a panel, and I'd just appreciate if you could help me with some local knowledge, if that's possible. So, from our drive around, there's sort of a village square area in the Shotover countryside of the development on the south side of State Highway 6. And from recollection, there's a cafe there. Is there any other retail offer in that location?
On the Shotover country or Hayes Creek side?
On the Shotover country, I think. Or it might be the Lake Hayes side. So sort of, as you come down Howard's Drive and head east.
Head east, yep.
Yep.
Lake Hayes estate.
Lake Hayes, apologies. So on
Yes.
the Lake Hayes side,
Yes,
you've got your little village square, sort of village green area and a cafe. Is there any other retail offer there at the moment?
Other than no, I don't think so. There's the school just round the corner.
No, there was
I don't think so.
there was a small sort of on the spot type retail offering. I'm not sure if that's still there or not. The only other commercial, sorry to jump in,
You're right.
if this is a combination question, the only other commercial activity within that vicinity is in the Carroll Heights,
Yep.
Carroll Park, which is a night and day small
another
scale
cafe.
supermarket. Frank's very popular
Yep.
cafe, and some sort of pseudo medical type
Mm-hmm.
activities.
And obviously there's a primary school in Shotover country. Are there any other sort of small local convenience stores or cafes that you're aware of in the area?
No,
Not that I'm aware
no,
of.
not on this side of the bridge, on that side of the Shotover.
I think there is one that hasn't been established but consented to the Bridesdale Special Housing Area, consent to Red Cottage down the bottom of
Okay,
Lake Hayes.
thank you.
I don't believe that's been established.
Yeah.
Mm-hmm.
So the reason I'm asking, and this might be preempting possibly a planning question, is we've been talking with a lot of the transport experts for council, and in terms of public transport, certainly 400 metres is generally considered to be a very readily accessible walking distance. So just thinking about the relationship between your site, the Village Green and Lake Hayes and Cowrow Park, and that sort of 400 metre walk, what I'm seeing from drawing some circles on Google Earth is that you're actually overlapping those already. So I guess it's just asking the question and testing that if we have those facilities within a 400 metre walk, one either side, that sort of encompasses your middle catchment, is there actually a need for that middle catchment to be specifically provided for? Because you've already got provision at either end.
Looking at what's already there, and a perfect example of the coffee shop in the little square, and as Josh alluded to, it was, I think, an opportunity that was missed to not further that square and make it a proper village square. It's put an isolated coffee shop in there. So the problem with it is that it just needs to be looked at as a coffee shop. Whereas what we're proposing up the hill is that we put in a proper integrated development that will look after a number of businesses that will rely on each other. And certainly I'm aware as a landlord and developer about competition, and my philosophy is that full buildings is better than empty buildings with the desire that we should be doing something else. The tenant mix that I would envisage putting in there wouldn't be you could call it self-sustaining, but we put in a number of businesses that would be complementary to each other. So then you don't look at them in isolation, like your coffee shop, perhaps another couple of shops somewhere else, because as soon as that impetus moves away, then they're just an isolated coffee shop.
Yeah, no, I do understand that, but just looking at the walk distance of your catchment to your, and I appreciate it's not as integrated as you may be envisaging, but what's available at Carrow Park in your Franks in the night and day, you know, you're already picking up a chunk of Shotover country and some of Lake Hayes. With your site being elevated, and you've got to go around the corner and up, you're not really getting any sort of walk cycle benefit from what I can see in terms of your catchment into Lake Hayes. It's just whether that's something you've thought about at this point.
For sure. I mean, there's a massive catchment going to become available straight across the road in the form of the hospital and the country club, and it's on the safer side of State Highway 6 than on the north side of State Highway 6, which is going to be also envisaged for commercial. And you're going to ask those people to walk straight past our place to go across State Highway 6, and it's I'm not sure how you're going to get your people across there.
Okay.
There's certainly no indication on the proposed construction plans to allow for anything other than vehicular access to the north side development.
So I think things may have moved on quite a bit since that point. So there's been quite a lot of work with the transportation experts, and they're now at a point where they've agreed that an underpass is not a great idea.
Good.
Yes, it's slightly old-fashioned thinking, and that signals at Howard's Drive, State Highway 6, and at-grade crossings is far more appropriate. So I think that interface would be potentially a lot easier than you may have been envisaging.
Yes.
So with the development that's going on the opposite side of Howard's Drive, once again, the benefit of good old Google Earth, I can see road connections up at First Avenue, which is north of your site. Are you aware of whether there would be any connections out of that site closer to yours?
I need to
speak to that if you want. My understanding is that the country club has that main access, and it's fed from that main access, so that it's.
Yeah. So there wouldn't be another road access coming out from that new part of the retirement village?
No, not on the resource consent.
There's
Okay.
there's secondary access towards where you actually access Kawerau Park to access the southern portion of it. My understanding is the avenues within the wider country club area are internalised with no additional road access.
Okay, that's great. Thank you very much.
Thank you.
Thank you, Mr. McFarlane.
And I'm not a local, so just picking up on the questions that we're just having. When we drove round, the site has high hedges, etc., so didn't see the site per se, but then you dropped down a significant terrace, and when you mention pedestrian mobility, etc., are you thinking from the Queenstown Country Club, but you've talked about Lake Hayes, etc., coming up that terrace? And I realise there's the 400 metres, there's the 800 metres, there's different sizes, but also that the elevation element to that as well, rather than just a pure circle on Google Earth.
Well, I think unfortunately the elevations there, we can do little about it. The advantage of the site is that it's in a position that it can best utilise that access. I suppose at the end of the day that could be a discussion with council as to how they're going to access out of Lake Hayes, even up onto the upper plateau to get to the new development on the other side. It's still going to be of the same, they're going to have the same situation. That's something that I am very interested in, is that pedestrian access along, and you would have noticed that big long line of trees. That's, you know, we need to understand what's happening in there. So we could probably pull a pedestrian walkway into our site, or we can best join our development into the plans that go down that hill. At the moment it's a gravel track that goes in two different directions. One's steep and one's not so steep. I think we've got to understand what's happening outside of that, and certainly that's part of our development vision, as to how best incorporate that access to get them, because let's face it, the best audience I've got is just down the hill. So the easiest way I can get them up to where we are, you know, I'm willing to work in with any reasonable and feasible project.
And there is a track there, just for completeness, there's a track there already. It just sort of goes nowhere and just stops.
It stops at our gate.
I understand that is protected by council easements and in favour of council, and so the foundations are there. It just doesn't connect to anything at this stage.
And potentially there'll be, who knows, a school on the other side as well.
Yeah.
Yep. And then you, Mr. Lecker, you talked about, but it's more for Mr. McFarlane, but as a team, you spoke about the sort of, what's the word you were, corridor, I think was the word you used. And in terms of, and you've been completely upfront in terms of the economic evidence of Ms. Hampson, and her concerns, and it's just your take on these, Mr. McFarlane. I've heard Mr. Lecky's, but your take in terms of the corridor and her concern that actually putting in a commercial development here will compete in the same market as the new commercial centre, and also as the, and I'm going to get it wrong, but I think it's the Kaurau Centre. And how do you, given your sort of knowledge and experience in the sector, consider that position?
Well, I certainly think that there is not enough of this type of commercial development available, even with the proposed one on the other side of the road, and the amount of residents that you're looking at putting in on the north side of the road. It's nowhere near enough. And certainly making the offering, and what I've, from the limited exposure I've had in the Wakatipu Basin, is that it is very isolated. You do get pockets of bits and pieces, and when we get that, we of course have little competition, and of course little competition, up goes the price. And I think in this instance, and the one across the road, the new proposed one, will be very, very good for offering a mixed use, office space, people wanting to have it, not necessarily work at home, but come and have an office close by. No, the short answer is you could put in 5 times this and it'll fill up.
Well, that's my next question, is just whether you're aware of the proposal to increase the size of the commercial, Mr. The team is, but to increase the commercial area by 50%, and whether there's any just sort of comment on that.
I can start, and conscious to let Mr. McFarlane answer his own questions as well, but it occurred to me in relation to the Hutchinson evidence and the discussion there, where it seems that Ms. Hampson had made a concession that if that land was rezoned for residential, it would therefore trigger the need for additional commercial, and that rang some alarm bells to me. That signals how finely balanced the provision of commercial is, if adding that small amount can then move her recommendation to support an additional 2,000 squares. So to echo Mr. McFarlane's thoughts, I don't think the increase in the size in an evidential sense will cause an issue to also accepting the relief of Doolittle. I still think there'd be plenty of demand but I'll let you answer that, Angus.
Well, no, for sure. I'm very happy
The
with what we've got proposed.
The one thing potentially where Ms Hampson was coming from with the Hutchinson Trust is, from memory, that's hundreds, 300 plus. So it's a large number that was sort of driving through.
Yeah, it's a large number in the context of the variation, but there's 4,500 existing residences.
So
in
it's
there.
back to that.
Correct, yeah,
that
and that
catchment,
connectivity and integration of that catchment. Yeah.
And just then back to the walking. Do you foresee, and I know there's evidence, etc., and submissions, but is it realistic to foresee walking, or is it going to be more driving that would actually, people would drive? They'd be driving home from work, they'd be driving to work, they'd be driving to drop the kids off at school on the other side or whatever, and would pop in more in a convenience manner.
As a local, my response to that is there's probably a need for a transition, but that's going to take time. And I think realistically, it is going to be a driving catchment for some time until the behaviours change. And you've only got to go to, it used to be called Akarua, but it has a new name now, but the cafe down the other end of Lake Hayes on a Saturday morning, at the other end of the lake, and it's absolutely packed. You can't get a booking unless you book a month in advance. So people are driving, everyone is driving there.
I thought you were going to tell me people were biking there. I was very
No, they're not yet. Not yet.
I think the problem is that we as humans are very lazy, and we aren't going to adapt quickly, and what we don't like is being told what we can do and can't do. And if we're told we have to walk, then we want to drive. The thing is that in this instance, we can give them the opportunity to walk safely, mobility, scooters, all sorts of stuff other than driving. The good thing about this also is that it's left in, left out. It's on the way home. There's a whole load of benefits there socially that would encourage pedestrian access into both Hayes Creek shot over and over into the greater part of the country club. So I don't feel that it's isolated in any way. I think it's, as Josh has indicated, and it's on the corridor. It's a wonderful opportunity.
Design can drive behaviour though, so the country club's a good example that there are physical connections between the country club and Carlisle Park, but they're blocked off. But I do know people in the country club who have therefore bought mobility scooters to take them to drive to the cafe. So physically blocking the access has stopped them getting into their car, and it would be, I'd recommend the panel go and have a look, and people do go between the country club and Carlisle Park.
Yep.
With whether that counts as active transport, I'm not sure, but an urban designer might be able to answer that.
Thank you. Thank you very much, Mr. McFarlane. So
Thank you.
we'll go now to, and we've got the summary. Thank you.
Yes, thank you.
That's great, thanks.
Cool.
So, Mr. Dunn, over to you.
Cool. Thank you. Yeah, I'll just read out my summary and take questions at the end. I think a lot of it has already been canvassed, but to put a planning perspective on it.
And also, if something has been canvassed and you just, as you go through, want to elaborate on
Yeah,
it,
absolutely.
please just do, and we'll take notes.
Cool, thank you. Also added paragraph 4, so appropriateness of relief. The overarching purpose of the zone is to ensure a self-sustaining community that integrates with nearby zones and that is also inclusive of communities in nearby zones. Objective 49.2.1 requires that development complements and integrates with adjoining urban development at Ladies Mile and development south of State Highway 6. From an integration point of view, restricting commercial activities to be on the northern side will only result in future commercial activities being centralised for the new northern community. This conflicts with Objective 49.2.1. It is commonly accepted that the existing Shotover Country and Lake Hayes estate communities do not have sufficient commercial zoned land. Commercial precinct zoning on the site would result in the creation of a commercial corridor extending from the notified commercial precinct in the north to Carlisle Park in the south. While this corridor would be bisected by the highway and the open space precinct, the area will still clearly be non-residential in nature. And just expanding on a topic point that was discussed before about the existing Lake Hayes Cafe and Carterell Park, and is there going to be demand for this? As Mr. McFarlane alluded to, I mean, the Lake Hayes Green, that is essentially only one cafe. I think you can buy milk and bread from there. And likewise with Carterell Park, that's got your Frank's Cafe, Night and Day, and some associated, what I would call medical activities. So the offering in those existing areas is really limited. If you establish a site with a number of commercial activities, people may go there and do or purchase, from 3 different stores. There's more variety. Having the Village Green, just a cafe, unless you're going for breakfast or lunch, there's no real, I guess, need to go there. And Council's economic evidence primarily seems concerned that the commercial precinct zoning on the submitter's land will compromise and compete with the vitality and general operation of the notified commercial precinct area. So we have now removed any relief seeking large format retail from the site, so that should alleviate concerns regarding excessive large format retail floor space. As Mr. Leakey has alluded to, Ms Hampson states that she could support a neighbourhood centre on the Anna Hutchison Family Trust land should this submission be accepted, as this would provide additional commercial floor space for the future population to the west of the zone. I consider extensive consideration appears to be given to new residents of the zone. On the other hand, there appears to be little to no consideration for existing residents and their current needs. Rezoning of the site to commercial precinct will allow existing residents to walk, cycle to access these commercial services. And just touching what we talked about before, yes, people are bound to drive, especially with the left hand in, left hand out. The bonus of that is existing residents of Lake Hayes Estate, for example, can simply turn right at the intersection, grab something from this site and then proceed home without having to turn left into the much more dense Ladies Mile area on the northern side of the highway, then cross back over what will be a very busy intersection. So yeah, in my view, that is definitely a positive. And likewise, talking about the existing walking tracks, there's an extensive trail of walking tracks throughout Lake Hayes, Shotover, Carterell Park. Yes, they're not in the greatest condition, some of them, but they are close to the Doolittle site. Connections can easily be made. As part of a resource consent package, pedestrian access is considered, and there would be discretion for upgrades to those existing tracks to provide for that for mobility and whatnot. Rezoning the site to commercial precinct will allow existing residents. Sorry, I just said that. This in turn will reduce vehicle trips and provide the opportunity for active travel within these existing neighbourhoods and communities. A conservative estimate of the additional commercial precinct zoning on the southern portion of Ladies Mile results in 50 less passenger trips out of Lake Hayes Estate and Shotover country per day. Ms Hampson supports the live-work developments on the site, provided they exclude retail activities. While this would allow some commercial development of the site, it would not provide for the day-to-day needs of residents located within the southern portion of the Eastern Access Corridor. And just expanding on what Mr. Leakey said with his experience with these live-work developments, the type of commercial activities that can occur within these developments is essentially very restricted unless you want an extra large office to work at from home. The additional opportunities there are more restricted, hence why people seek consents for retail activity.
And sorry, just to touch on that while we're there, and sorry, panel, but just in terms of The experience as I take it is that, in effect, that gets a zone and then people later on just apply for consent to change it.
If they,
And then over time you get a sort of muddle of different bits and pieces.
correct, yeah. They, from existing experience being in working as a planner within the district for 5-6 years, that is definitely the feedback we get from people. People want the opportunity to start a business that people can come and purchase from the site. Restricting to working from your residence is essentially, in my view, a large home occupation, which doesn't offer as many opportunities.
Cool, thank you.
With regard to the wider Queenstown urban area and existing primary commercial centres of the Queenstown CBD and Frankton, the proposed commercial precinct zoning on the site will not compete or undermine these areas. The commercial precinct zoning on the site will provide day-to-day commercial services for Eastern Corridor residents, including existing residents. Overall, I consider rezoning of the Doolittle site to commercial precinct would better achieve the objectives of the variation compared to the notified low-density residential zoning. If a rezoning to commercial precinct is not granted, Doolittle supports a rezoning of the site to the proposed district plan high-density residential as considered appropriate in the rebuttal evidence of Jeffrey Brown dated 10 November 2023. Thank you.
Lovely. Thank you very much, Mr. Dunn. Now, questions again from the panel. Ian, do you have?
I do have some questions for you. Your client told us about his vision, the small-scale retail, cafes, boutique brewery. And at your paragraph 8 of your summary, you also touched on no large format retail being proposed. But in your evidence in chief, you've proposed to change the precinct rules to allow no large format retail caps of any kind specifically on your client's site. I don't see how those positions at all match up. Are you no longer recommending those changes?
Correct. So through planning conferencing, we remove that. Yep.
And just for, sorry.
Just hold on, Mr. Lecky. Are you now seeking any changes to the commercial precinct rules, other than just to have it apply to your client's land?
Just have it to apply, and because the structure plan doesn't have a height limit on the Doolittle land, we would also need a height limit.
Yes.
So we've proposed
Understand that.
Yeah.
The discussion in comparison with Ms Hampson, and in fairness to Ms Hampson, it was a hypothetical. If that was added, then maybe this comes along, and she talked about a neighbourhood centre zone. And I can understand, and we've heard evidence on centre hierarchies and how a neighbourhood centre that only allows for limited small things wouldn't try and cannibalise or compete with the principal centre for things like supermarkets and bigger things. But again, the relief you're seeking isn't a neighbourhood centre, you want the town centre zone.
Correct.
If your client's relief isn't most of the things that the town centre zone enables and is only for a handful of reasonably small scale things, wouldn't your Section 32 analysis lead you to instead be seeking something like a neighbourhood centre zone on your client's land?
Yeah, I guess in that Section 32, just thinking of that one. I guess where we started and where we are at now is quite different.
So where we are now?
Yep, is definitely different. And looking at this whole idea of a commercial corridor not having large format retail on the Doolittle site, in my view, the corridor would complement one another, the different commercial areas to establish that corridor. So, yep, having the smaller scale and the provisions of the commercial precinct zoning on the site, because I mean the commercial precinct rules for commercial activities are still relatively small scale in the scheme of your larger Frankton and Queenstown CBD rules. So in my view, the commercial precinct zoning is almost a neighbourhood zoning of some description.
But if your client's land is zoned the commercial precinct, and the commercial precinct enables a supermarket, what's to stop it going on your client's land?
That is a good question. We would be happy to have a specific clause in the commercial precinct that states no large format retail on the site.
Okay. The idea of the commercial corridor, I'm looking now at the Annexure A, purely because I know it'll be handy for you too to look at. Of all of the things you put in evidence, the commercial corridor was the one I struggled the most to understand.
Yeah.
And I don't, maybe what you think of a commercial corridor is not what I imagine it to be, because if I start from the northern side in the proposed zone, I see a commercial zone proposed on one side of a road, then we cross the highway, then we have about 250 metres of retirement village and open space, then we have on one side your client's proposed site, and then another about 100 metre gap of non-commercial stuff to the Kawara Park. And so we've got a road that has bits of commercial stuff on it, but if we looked at the linear length of both sides, it's probably more non-commercial than commercial. So, and that's not a criticism, that's just me explaining to you what I saw when I was trying to reflect on what a commercial corridor is. So what to you, what in your view is a commercial corridor?
A commercial corridor, in my view, is made up of essentially non-residential activities to start with. And looking at this plan, it is relatively zoomed in as well. I think, if we look at the wider eastern access corridor as a whole, which includes, all the shot over country down there, which is missing, if we were looking at this plan as a whole and looking at the centre of the eastern access corridor, we would see, elements of this non-residential activity where the commercial centres are focused, acknowledging, which I agree with, yes, there are different commercial centres within this portion of the eastern access corridor. But in my view, even though it is bisected by open space, the country club as a whole can still read from a high level as a sort of corridor, and I think it is also a difference of opinion. Some people may not consider that to be a corridor. I would also call it a non-residential area, would be another way of putting it. A non-residential area that could support nodes of commercial activity.
Okay, look, I don't have any other questions for you, but thank you for that.
Thank you.
I have a question, and it's more to try and get an understanding in the head, along a similar vein to you've just been considering, and I'm not sure to which you three is going to answer it. And it's really come about how it's presented, and there's a preference for it to be commercial, and if not, high-density residential. And you're alluding to, well, maybe high-density residential might have a really good fit for retail to be the base fit, with live, work, fun activities associated with that. Is the expectation that irrespective of which as long as there's retail activity available, you envisage seeing similar types of retail activity in that space?
I can start from a legal perspective. It's potentially a planning question as well for Mr. Dunn, because the types of commercial activity that would likely be consentable or anticipated in a high-density residential scenario are much more limited to sort of home-type activities than what would be anticipated if it was zone commercial. So they are still quite different outcomes, which is why Doolittle still prefers the commercial overlay. Mr. Dunn, have you got anything to add to that in terms of the sorts of activity?
Yeah, so just touching on the high-density residential. So the proposed district plan high-density residential does allow 100 metres squared of floor space per site of commercial activity. If you look at minimum subdivision standards, if the site was subdivided, that would actually be quite enabling of commercial activities. In my opinion, that is a superior outcome compared to a bespoke work, live, unit situation. So that's my position on it.
I think my question was more, are we expecting, I don't know, boutique breweries and other little things popping up there which then are providing the types of services that you have discussed initially?
It's potentially one for Angus, really, around the sorts of activities that
Well, I think
you want.
It's a mixed business use is essentially what makes that community or that hub work, and that's what we'd be looking at the golden opportunities there is to bring in the likes of your office accommodation, your retail, small amount of residential, not a preference. Other than it's of a size, any smaller than that would become isolated, the same as we'd get down on the village green again. But I would like also to understand what's happening with the balance of the north of our site up through to State Highway 6 of what's happening with the council land. That'll be a secret which we'd like to understand as a site owner. And then once again we have access, pedestrian, vehicular access, understanding of what's happening along there, and that would also enhance or answer the question as to if it was a corridor or not.
Yeah, and actually that's a really good point you've just brought up there. So the open space precinct essentially diverts back to the open space and recreation zone of the proposed district plan, and the zoning essentially does allow for commercial activities, cafes and whatnot within the open space zone as a controlled activity or RD activity. And going through that open space chapter, commercial activities are anticipated. So yeah, once again, what Mr McFarlane just alluded to, depending on what the council does, there could be additional commercial opportunities between the Doolittle site and the highway, and if that was ever established, that would be, in my view, a true commercial corridor. But in summary, commercial corridor in that area cannot be excluded.
And would it then be your understanding that because we're creating all these sports fields and not everyone that's going to be using those fields is walking to the site, there'll be parking and those sort of things associated with it and potentially near the Doolittle, not knowing exactly what the layout is and how they expect to use the reserve?
I would expect that when council comes in for their, master plan for the site, there would be provision for parking, just like at the current Queenstown Event Centre. People drive there, use the facilities. I note in the Event Centre there's a small cafe. It's very small scale. This is a much larger, area. It's one of the unknowns, I guess. Yeah. But I guess I would assume council would definitely be putting parking on the site.
And that's where the main access road is, so logically you would put it on the side of that section which is near the Doolittle land. No, that's all for me, thanks. Thank you.
Sorry, I'm going to jump in for you. Mr Dunn, just before I go down my line of questions for you, can you just clarify for me, on 2A you've put a height for the commercial precinct as a maximum. What height are we talking about for the high density residential?
So we're proposing proposed district plan high density residential, and the current height limit for a flat site is 12 metres.
Okay, so same.
Yes, correct.
Okay, thank you. So having been out on site, it's very elevated. It's the site's towards the edge of that top terrace. Can you comment on the bulk of that development, irrespective of whether it's commercial or high density, in terms of visual and landscape for residents in that area? Because to me it seems that at the edge of that terrace it would be quite a bulky site visually. Can you make comments on that?
Yeah, there is an escarpment there. I guess any development there, if it was built right to the terrace edge, would be clearly visible for residents of Lake Hayes estate. Noting in the underlying subdivision too, there are geotechnical constraints near that terrace edge, and depending on the exact built form that is proposed, I would imagine if the building was larger there may be more constraints. That is something we can definitely explore further. If we have a setback from that terrace edge, that could be appropriate to mitigate some of those visual effects. I think at the end of the day, though, any development there, whether it is low density or high density, is now supported by council, there would be an element of built form that would be visible.
Right, thank you. And just one other comment. It's quite interesting hearing that narrative around the southern side of State Highway 6. We've got the community, but we don't have a lot of services and areas to support the community. Is there support through preparation of your submission and the work through to today? Has there been dialogue with some of those large landowners like the Country Club? Has there been any dialogue with what those residents or those communities would be wanting? Have you had any dialogue?
Well, the limited, and it is limited because I'm unsure what's happening yet, but there's certainly a need and an interest from the residents of Lake Hayes Estate to have certainly commercial activities in there. I have a restaurant slash brewery bar. They've expressed a huge amount of interest of going in. So we've got that social element that's seeking interest in what's happening up on the top of the hill.
Okay. Because you see, it seems to have quite diverse communities down there. You've got the school, you've got a lot of young families down the bottom, and up the top you've got the other end of the age spectrum with the Country Club. So I was just curious whether there'd been any dialogue around the specific type of activities. You've talked about office. Obviously that's probably more likely to be driven demand from the families rather than the people in the Country Club. So I was curious when you'd made the comment around office space, where you had your information around the demand for office space on the side of the, wherever we are now, the other side of the Shotover Bridge.
Well, once again, that's our desire is to do something underneath that blanket of commercial activity, because and then we can be sympathetic as to what our tenants or potential clients want, and we'll provide that. We've had enough discussions with people in the larger area to know what we would like to put in there.
So what I'm trying to understand is whether the demand exists already, or whether you know that if you create the space, the demand will be there for it.
Well, I'm certainly a fan of build it and they will come.
Right, thank you.
My experience is, well, I've owned some land in Glenda Drive, exceptionally difficult to get anything other than industrial underway in there. So the demand is there.
Thank you. Nothing more.
That's my turn. Mr. Dunn, could I take you to paragraph 12 of your summary? Yep. So, accepting you're not a transportation specialist, where did you get the 50 less passenger trips from?
That was from the Lumen report, the greenhouse gas report we commissioned, that was attached to my statement of evidence.
Thank you. So the reason I'm interested in that is if that is, I accept an at least number, I've been having a bit of a Google and looking at traffic volumes on Howard's Drive up at the top end near State Highway 6, there are around 6,800 vehicles per day. So I would just be really interested in your views on the significance of a 50 vehicle per day saving out of 6,800. So just to give you some feel, it's about 0.7%, and the typical variation you get in traffic day to day can be quite large, but we generally take a ballpark of 5%. So I'm just interested in your views on the significance of 0.7%.
Yeah.
In that context.
No, good question. And as Mr. McFarlane alluded to before, you know, people are going to drive. In the meantime, it's a behavioural change. I think 50 overall is not significant at all, considering the overall number. However, you know, if the commercial precinct zoning is established, commercial businesses are established, then they are established in that location, and over time, behaviour can change. That behaviour, you know, may change as a result of higher petrol prices or other impacts in the area. But yeah, on face value, 50 not significant, my opinion.
Okay, thank you. And your client mentioned earlier about left and left out access. Have you had any specialist advice on that at all?
On traffic advice on it?
Yep.
No, because we've
Okay.
essentially,
It's,
if
well,
you'd
yeah.
like me to explain why we got those plans done of our left in and out. It was Lad-
It's okay, Mr. McFarlane. I'm quite comfortable. I just
Okay,
wanted to
thank you.
understand if you had had advice, and in relation to the plan change, the answer is no, but you do have plans drawn up. Am I correct in that?
yes.
Yeah, thank you.
Yes, are those plans also attached to the statement of evidence?
That's it, thank you.
Excellent, and thank you very much. The questions have all been taken, and certainly I've got a much better understanding now, not only of your position, but also of your plans, etc., and thinking for the site. So thank you all very much.
I've got one more.
Oh, one more.
To Mr. Leckie.
Yes, Mr. Monroe.
There are, all things being equal, there are two very compelling aspects to the case. One is we're here because we're trying to deal with some historic, serious transport issues.
Yes.
Big part of that is Lake Hayes Estate, trying to have a country, and even with the proposed zone, people still have to get across State Highway to the new commercial centre, and there may be a sweet spot where we can be even more efficient while still achieve all the other things that are being sought. That's one, I think, at face value, pretty convincing issue. The second is without knowing what the council might do with this open space precinct, but the idea of one day having lots and lots of people coming here for recreational use, being able to go to a dairy or a lunch bar directly next to it without having to get across highways or other things, also could be a pretty convincing thing. And if there are floodlights or other things there, houses right next to it might not be the great thing. So I can say, yep, there's some interesting things there. I can't imagine, and I've been racking my brain while the other commissioners have been asking questions, I can't imagine or think of another example anywhere in the country where a town centre zone is split into two bits with a 200 odd metre gap between them. If we agreed with your case to the extent that only went as far as a neighbourhood centre zone, is that in the scope of what you're seeking, or is it not acceptable? Is it the full commercial precinct or high density residential zone, and that's it?
No, yes, it would be within the scope. I mean, the effects, looking at the effects part of that test, the effects would be peered back from the town centre.
Okay. I
Approach.
appreciate it might not be what your client
No,
wants.
no, and I sort of was acknowledging that it's not what they're seeking, but in a scope sense, I think it's certainly
Okay.
it would be within the realm. One of the points that occurred to me during other answers was just a plan integrity point, in that this variation doesn't introduce a full raft of zones, so that would just need some thinking around how that sort of fitted within that broader picture. But I think conceptually it would be within.
We've got David Allen on the case here.
Mr. Allen can solve plan integrity issues, I'm sure.
No, look, I appreciate you putting that in the mix, and that's something we might actually ask the council to come back to us, because it was actually one of the parties to this that introduced circumstances around which a neighbourhood centre zone might be available, and the council might have a view on the circumstances in which that might be acceptable as a matter of legal principle and plan integrity anyway. But I really appreciate that little tack on there. Thank you, Mr. Leckie.
Thank you. And I just had one more point while you had given me the talking stick, Mr. Munro. It does. It segues from it. But you asked Mr. Dunn around the corridor, and I put in my legal submissions the centres and corridor concept from the unitary plan that many of us were involved in. But I think the other part of a corridor, there is a similarity here. It's not just about the activities, it's about the role of the road. And Howard's Drive does fulfil a a critical access point in this broader ladies' mile area. So I'll just add that the role of the road.
Dunn said that when I asked him at the corridor, and he talked about the bigger context. I don't think he maybe was as eloquent as you, but he makes the same point you've just.
It's good to have said the same thing, so I'll stop talking.
But I understand it's really important to you.
Thanks.
And I'll keep well away from drafting provisions. Thank you very much. Thank you to the whole team, and also thank you for jumping into a gap that appeared. So that's much appreciated.
Thank you.
Have a lovely afternoon. Thank you.
Thank you.
Now I've got bits of paper everywhere.
I saw your name.
I've just missed the vote.
Thank you. The reason I'm looking at the timetable, etc., is apparently Mr. Giddens is unwell, and Corona Trust has asked to reschedule until next week, the 14th. We do have the Cocoa Ridge team, I suspect, and sorry, it's an assumption, hopefully I'm right, here, and it's earlier than you were anticipating. We also missed our site visit yesterday, but we're trying to work on one tomorrow. But the floor could be yours right now, if you would like to have it. Or we could wait and have an adjournment and come back after afternoon tea.
I think we'll adjourn. We've just got some paper to shuffle around and.
Perfect.
Yeah. So that would suit us well. Thank you.
Okay, we'll take a break and we'll be back at, we'll take 20 minutes and we'll be back at 3. Perfect. Thank you.
the only thing would be, if there's a 50-foot space in a, which, to be fair, there is one or two little spaces on the stage. Wednesday afternoon, potentially. Again, if you just talk to me, I think it would only be Wednesday afternoon. But it would.
Too much sitting.
Well, it's that sitting overnight. You really need to do it.
Yeah.
Otherwise,
Maybe like 2-2 or just like 1:15.
2-2, I think.
If we can it's not a problem just to sit because it's like a bit. Let's see. Yeah.
Right,
and
so
it's
you want us
worth
to
it.
cozy up basically around the mics. Is that
Yeah,
what you're
yeah.
saying?
It's also okay if there's like a bigger distance, you can just move it around like whenever someone's speaking. Yeah, thank you.
There's no way
Judith can use Google Earth and glancing
She
across the-
probably uses it all.
This is
She must be an
way
engineer.
beyond my expertise. Way beyond. Hey, how are you? Good, good, thank you. Nice to see you again. Yeah, likewise. Much nicer sort of location.
When I
Yeah, what's the hut?
should I just ask if I'll have one? Yeah, and this is the first council I've had to speak with.
Yes.
So I hadn't really thought about it either. And I didn't even realise what the dispersal was, now I know.
Yeah, and from what I understand, until this hearing, they did use to meet with them, but now they don't. I don't know what the is behind that, but I just know they can.
Yeah. No, it's neither here nor there.
Is
So I,
your accommodation good though?
oh yeah, no, it is. You know, it's kind of catching us up in doing my breakfast, those sort of things. But couldn't be bothered to get enough food to sort out the one, so just eating in the restaurant charging there. But when I leave tomorrow, I can do a wash up and pay for all the restaurants separate, and I won't come through and
No, it's not possible.
yeah, no, that's all fine, but I'll give that a go,
Awesome.
and then they might be able to just reissue the invoice. It appears it's not paid, which appeared to be the trigger.
Oh, it's because I'm in the process of paying for it now. It's only just come through, so it'll get
Yeah,
done.
so expect them to reissue it.
Yeah,
And amended
yeah,
invoice
no, that's all.
tomorrow, and then we'll sort it out.
Yeah,
No worries.
happy days.
Yeah, it's all good.
Thank you.
welcome back everybody, and we have the Cocoa Ridge team in front of us. As I alluded to earlier, and I should turn on my mic, the Corona Trust team hasn't turned up and Mr Giddens is unwell. We've had a discussion, but just thought first whether there's any comment or views or thoughts from the Cocoa Ridge team, who are all here.
Yes. So my name is Christy. I'll just introduce the team first and come back to your point. To my left, we've got Tim Allen, the director. In the rear of the room, we have Mr Wayne Foley for Cocoa Ridge as well. We also have Blair Devlin, the planner, and to my right is Dave Compton-Mowen, our landscape architect. So we're all here and present today and somewhat surprised to find that Corona Trust isn't available. We note that both of their witnesses aren't here, despite us not knowing that they intended not to come today. So clearly there was communication between the two witnesses, but not with any other party, which is quite disappointing from our perspective. We had intended to go after Corona Trust. The main reason is that we had concerns about the accuracy of their information to the panel, which we've outlined in some of our written evidence, but we did want the opportunity to talk to any other topics that they raised in the hearing itself. So for us, this presents somewhat of an awkward situation. There's probably some options for working through that. One thing that we need to be conscious of is that Mr Devlin's not available tomorrow. We'd intended for him to present to the panel today, and how we thought. Fair
enough.
Yeah, how we thought our case would run, assuming it had gone according to schedule, was that after introducing everyone, Mr Allen was going to outline the parameters and describe the subdivision and orient the panel. Then Mr Devlin was going to speak to the planning issues, followed by Mr Compton-Mowen to explain the landscape side of dimensions of the issues, and then Mr Allen was going to conclude with his evidence, and then followed by legal submissions, because this matter doesn't necessarily turn directly on the legal issues, it's more about the factual assessment. So that's how we intended to present our case. We're open to suggestions or options, but we still want that opportunity to respond to anything new that Corona Trust raises.
And thank you for that, and that does give another point. From the panel's position, we weren't told. We are highly unimpressed, and it does put the panel on the back foot. We had planned next Friday to do our start the deliberations before Christmas, so we could get a plan in place to move through in advance of the closing, getting some of the parameters of the decision underway, so we can meet all the timeframes that we've got. And certainly from the panel's position, we don't want to lose next Friday, which is the discussion that's being had with the hearing administrator. Since we were not given notice, and it appears Mr Giddens is in Christchurch, so no, notice should and could have been given, and as you alluded to, there are two witnesses, and no doubt other people as well who could have, out of courtesy, let the hearings administrator know. Our preference as the panel is that any questions we've got of the Corona Trust experts we'll put in writing. We've done it already with the council earlier, and then we'll give them 2 weeks, or actually maybe a bit less. I'll need to think about that, but I'll issue a minute tonight. We'll give them either 5 working days or 10 working days to respond to our questions. It's just, of course, we've got our questions but not written out per se, so it will take the panel a few days to do it, and then maybe 5 days to respond. So the preference again is you're all here, we have limited time, we want to have a chat tomorrow. We've also got a site visit potentially being planned. We don't want to lose that. We're in a streamlined planning process. We cannot be held up in this way, especially where there's no knowledge at all beforehand of what's going on. And so we won't be. And so up to you if you'd like to proceed. If you don't proceed, we could do written questions for your witnesses as well. Seeing they're all here, hopefully that's not required. But up to you in terms of that process. But certainly for Corona Trust, and I'm not sure if they're listening, but if they are, the direction will be that we don't have time to fit them in the timetable. We haven't been given the courtesy of advance notice. We will prepare our questions in writing to their experts and they can answer them. And then we'll just forge on with those responses and obviously with the material that you provide today and tomorrow morning.
Yep.
Well, I think that sounds a practical solution moving forward. And I think we'll just charge forward and conscious of your time, we will be as efficient as we can and maybe even pull forward the site visit, which we can go straight after we've heard, or I know you've got Mr. Colin Smith, is it, from Transport presenting, because I came on the plane down with him, so I know he's here. So.
Yeah, well, I mean, we can see where we are. It might actually be worth trying to get in touch with Mr. Smith. Please, Lindley, if we've got a contact at all with him. And maybe the council, I think, was Mr.
We do.
Oh, pardon. Oh, okay. Wonderful, that's efficient.
We invited him out for dinner with us.
Because it might be if we're running earlier, Mr. Smith might have time earlier in the day because I'm not sure how we'll be going. Oh, no, Ms. Woods.
The only thing I would add to that is Mr. Shields has prepared the
Of course he has.
answers to the questions, which we are busy finalising now.
Fair enough.
We are intending to file them as soon as before or after 5 as possible.
Today?
Well, you asked for them before Mr. Smith appeared tomorrow.
I did, but yes, that's great.
So the only part of that would be to enable you to read those before Mr. Smith appears.
Yep.
My understanding is that Mr. Shields is already liaising with Mr. Smith about some of his components of that, so he is well across what we're preparing for that.
Perfect. Thank you. And it just illustrates the complete frustration of being thrown out of a timetable without any courtesy. So I'm expressing the absolute displeasure of the panel with that approach.
We'll stick to your program tomorrow. My flight's 4 o'clock, so I can show you through and then on the plane. So.
That's great.
Perfect.
But we've brought along the hard copies of the evidence summaries, legal submissions, and we also have just a clean outline of the subdivision that Mr. Alan is going to take you through. Sorry, brain fade.
It's always hard when you go from first names to surnames.
No, it is.
Yeah, I don't think they called Mr. Allen for quite some years. Right, shall I start?
No, just wait till I've got pictures.
Oh, all right.
Yeah.
Yeah.
Thank you.
Okay. Are we ready to start?
Yes. Oh, oops. Yes. Yes, thank you. I notice it's relatively long, so please could we, Mr. Allen, just move quickly through your summary.
Yes.
And Let's see where we get to.
Yes,
Oh.
actually, we were just planning to do an overview of the subdivision and then hand.
Oh,
to Mr.
and then
Dillon.
do that.
Yes.
Perfect, yes.
I was just conscious.
Carried away.
Yeah.
Thank you.
So I've
we'll
just
start
given you
with these.
three drawings, mainly because obviously there's a miscommunication somewhere in the system, and Wayne was waiting for you, and
Oh, last night.
last night in the rain. Last Monday, yeah. Anyway, so we'll catch up tomorrow, but just so you can orientate yourself to the site.
And we have driven along
The
here
highway?
as well.
No, we won't see much because
Yep.
if you've driven along the highway, there's...
We've driven along.
Oh, the road.
Drive.
Oh, okay, you have been in. Right, perfect.
Yep.
Okay, so that area there is, we call Cocoa Ridge, which is land we own, and council call it sub-area H2. They're exactly the same areas. The first picture just shows the subdivision that's essentially done. Practical completion was achieved on last stage last week, and paperwork's following to get title. There's already title on lots 1 to 26 are already titled, and as you can see, there's a little bit dated, but 14 have been sold. So time frame there, if we just flick over the next page, you can see that just the next one really just shows the numbers. And the substantial difference is that, as you'll see on the third plan, is that the stage 2, which is coloured in orange, required a bit more work in terms of resource consent because it was all those properties to some extent were covered by the 75 metre building restriction area that's currently in place, that this plan change is proposing to reduce to 25 metres. And so you'll see in the third page how that resulted in specified building platforms which are shaded in blue for stage 2, but there's no building platforms required for stage 1. They just stand in the standard large lot residential A rules. But as you can see, they all, apart from lot 30, have a setback of 25 metres from the state highway, and then they meet other rules for again, the large lot rules around 4 metre side setbacks and 10 metres from roading. Lot 30, because it's a difficult site, had to go within 6 metres of the state highway, but it's a long way. At that point, the highway's in a deep cut, so there's no real issues. And that was all worked through and agreed. Obviously, the council approved it on a non-notified basis. And that's where we are as an overview of the site, and then we'll just go into some of the details of follow through the Blair will pick up the planning issues that result from a rezoning, effectively, because it's already subdivided into 38 lots, which is 37 lots, sorry.
And can you just point out where this is?
All right, so on, and we'll get to more details on it, but the Corona Trust land is in this area here, and what the planners have agreed, area of interest, and we'll come to some more detail, is these 4 lots here, not any of the rest of the site. It's already been titled.
And we've driven along Max's way, I think it's
right, yes.
to the end.
To the end.
And then we turned around and drove
Right,
back
so
up.
you didn't actually go into
We
Mr.
didn't
Boyd's
go
property.
into the Corona Trust land,
No.
but we went to the gate.
Okay. So you have a good feel of how it's pretty well screened, the upper, with the existing trees and bits and pieces. So.
And we've been up Slope Hill as well.
Oh, okay.
So we've been able to look down across your land and down onto the Corona land.
Right.
Quite an impressive view from
Yes.
up there.
Yeah. So I mean, this plan change that goes ahead will change in substantial nature all that area, won't it? It'll become it'll all become urban like this part of the land is. Which, so I think at this point, because I know Blair is very keen to be heard, to hand over to Blair, I'll then come back and cover off my points later on, and I'll stick to the highlights given the length of...
Perfect. Lovely. Thank you very much, and thank you for that summary.
Unless there's any more questions on the context.
I don't from those, but any of the panel?
Not at this point.
No.
No. Lovely.
Yes.
Oh, yes.
Sorry, nodding and thinking at the same time. Thank you, Mr. Allen. I just want to confirm something in my own mind. So on page 2, lot 26 is coloured blue.
Yes.
It's 1.
Yes.
So I just want to double check in my own head that have lots 26 and 24, they've got titles. Has any work started on those at all?
You mean...
And physical works for building houses?
No.
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 That was it. Thank you.
Oh, I could just add to that. When you'll see it on, if you drove down the site, there are 5 houses completed or under construction.
There's a few when the road's closer to the escarpment that seem to be being built at the moment.
Yes.
Yep.
Yes. Yeah, it started.
Sorry,
started
that's a very poor description of where they are, but there were some framed...
There were some frames up and roofs on. But so that's they only got title 6th of October, those landowners. So quite a
This
bit of
year?
this year.
And
this shows you how fast it's going. Yeah. So
yeah.
I was surprised to see the frames up too.
Yeah.
No.
Okay.
Good afternoon, Commissioners. I will read my summary of evidence. It's reasonably short.
Perfect. Thank you.
My name is Blair Devlin.
You can skip that bit.
Yep. Since I prepared my planning evidence, I attended the planning...
You can skip that bit.
Yep. Just to note, I did only attend on one day for the site-specific, the Friday, so...
Yep.
At a high level, I support the overall council-led master plan approach to the wider Ladies Mile area rather than having multiple individual landowners undertaking their own consent or plan changes processes. I support the plan variation, including land south of the State Highway, which includes a mixture of land that has some development already approved, for example, Cocoa Ridge, or in progress, such as Queensland Country Club. This will help achieve the plan variation objectives, including creating an integrated urban environment. The Cocoa Ridge land comprises flat terraces, mostly below State Highway 6, and is well positioned to support a low to medium density housing development that is visually unobtrusive and sympathetic to the adjacent low-density Shotover Country subdivision. It is already within the urban growth boundary and zoned for residential development, as the large lot residential zoning is already an urban residential zone, just one with a very low density. The Cocoa Ridge subdivision consents enable 37 lots or 4.5 units per hectare. My evidence noted that the notified density for the Cocoa Ridge land, sub-area H2, was 60 units or just 7.2 residential units per hectare, which was much lower than the other LDR precincts, H1, which was 12 units per hectare, I1, 13 units per hectare, and J1, that is in the Section 32 report, but doesn't appear to have become a sub-area on the structure plan, but in the Section 32 report it had 32 units per hectare. In my opinion, both the Cocoa subdivision density and the notified provisions are not an efficient use of scarce land suitable for urban development in the Wakatipu Basin. This has been recognised through amendments to the H2 low-density residential precinct provisions that have largely been agreed with Mr Brown for the Council. I preferred a density of 13 units per hectare, as this is more akin to a low-density residential zone and more in alignment with the other low-density residential areas, including the adjoining Shotover Country Special Zone. Mr Brown, in his rebuttal, agrees with the requested increase in density to a maximum of 108 residential units, along with grandfathering clauses that recognise the existing Cocoa Ridge subdivision and seek to reconcile bulk and location controls for the existing lots of greater than 2,000 square metres with the new provisions that enable a denser form of development. The grandfathering clause would mean that owners of existing lots of greater than 2,000 square metres that wish to retain their lot size and not further subdivide would be bound by the PDP large lot residential A bulk and location controls and not be affected by provisions such as the maximum parking ratios. This is a pragmatic approach that seeks to reconcile the approved cocoa subdivisions with the new zone provisions.
Just, sorry, Mr. Devlin, there you said greater than 2,000 and you've got written less than?
Sorry, that is around the wrong way.
Yeah,
sorry.
Cool. Sorry, just if I come back to it, I'll forget that you've said.
That should be around the other way, that
Yep.
symbol, sorry. I agree with Mr. Brown and the rebuttal evidence of Mr. Shields that the land is in reasonable proximity to the future bus stops that are required to be established on the highway west of the Stalker Road intersection, with sub-area H2 being required to provide a link to the active travel link to this bus stop. Additionally, bus priority on Stalker Road is included in the QLDC Minor Improvements Program, and bus priority on State Highway 6 is included in the NZ Up program and required by the Pūtahi Ladies Mile transport staging triggers. For the reasons set out in my evidence, I also support the reduction in the building restriction area to 25 metres, the enabling of residential flats, the reduction in the minimum lot size to 300 square metres with a maximum of 108 residential units in total, and the deletion of H2 from the transport infrastructure staging requirement. Mr. Brown is in agreement with these requested changes. Turning now to the Corona Trust submission, the joint witness statement records that Mr. Giddens and I disagree on how the rezoning of the H2 area to a LDR precinct and associated changes will affect the Corona Trust land located below the Cocoa Ridge land. We disagree over the extent of the boundary setback and height control required. In my opinion, a minimum 4 metre setback from the escarpment edge rather than the cadastral boundary, and the normal height limit of 8 metres to be appropriate for an urban environment, recognising that a private covenant restricts building heights to 5.5 metres in any event. I note the cadastral boundary does not align with the top of the escarpment, so in practice, a 4 metre setback from the escarpment edge could result in buildings on or close to the property boundary. From a plan administration perspective, I consider a setback from the cadastral boundary will be easier to implement, and agree with Mr. Compton-Mowen that a 2 metre setback from the cadastral boundary, as per the proposed low-density residential precinct, will be indiscernible from the 4 metre setback that applies currently to the approved building platforms and is appropriate. This will achieve a minimum setback from the top of the escarpment of between 3.5 metres and 8 metres for lots 27 to 30. So that's obviously the focus for Corona Trust, is those lots. I do not consider the LDR provisions need to impose a 5.5 metre height limit to align with the private covenant, as private covenants are a private matter between the parties. There are a huge number of private covenants in place covering diverse matters such as fence types and the location of washing lines that do not get replicated through district plan provisions. I'm therefore happy with the standard 8 metre height limit applied to the LDR precinct and to let the private covenant remain as a private matter between the parties. Mr. Compton-Mowen and I know the interface between the Cocoa and Corona land very well as we prepared the subdivision application for Stage 2 of Cocoa Ridge, which included lots 27 to 30 of RM 211276, which Mr. Giddens, Mr. Brown and I agreed in the joint witness statement is the area of land in contention with regard to the effects of built form. Any provisions relating to setbacks from terrace edges need to focus on this location and not the entire terrace escarpment, because you'll see when you're on site that the Cocoa boundary dives down the escarpment.
Further along.
Yeah, and so
the east.
Yeah, so if you're talking about setbacks from boundaries and escarpments, because it changes there, have to be careful around provisions relating to that.
Well, also on the bit we're interested in, per se, for this discussion.
Yes.
It comes towards, is it lot 30 in the corner, more and more
correct
above the terrace.
Yes.
Yep.
There's a map on my evidence.
Yep.
Like to...
And that's what I've got in my mind. Right. So, yes, thank you. We'll come to that later on, I suspect.
My opinion is that a large setback from the cadastral boundary or top of the escarpment is not an efficient use of land and reflects an unreasonable expectation of how amenity values are to be managed for an area that is already an urban zone located within the urban growth boundary. I prefer the evidence of Mr. Compton Moen, which is 2 metre setback from cadastral boundary and recognition of the 5.5 metre private covenant height, and Mr. Skelton for the council, 4 metre setback from the escarpment and 5.5 metre height, over that of Ms. Mojini, 20 metre setback from the escarpment and 5.5 metre height, because her evidence did not recognise both sites within an urban zone and the urban growth boundary, and completed a landscape and visual effects assessment as if it were a rural zone building platform application. Did not recognise that the cadastral boundary is not located on the top of the escarpment, incorrectly stated there was a 10 metre setback requirement in the Cocoa Ridge subdivision consent, did not recognise the receiving environment as approved by RM 211276, did not recognise that the Cocoa Ridge platforms on lots 20 to 30 of that consent only required further assessment due to being within the 75 metre building restriction area, which was a control in relation to visual amenity from the state highway, not adjoining properties. Did not recognise that the terrace escarpments in the Shotover Country and Lake Hayes estate are privately owned and are not designated recreational reserves, and stated that 15 residential units could be located on the terrace edge overlooking the Corona land without explaining how that could occur. I consider Ms. Mojini and Mr. Giddens have unrealistic expectations with regard to the amenity values for the Corona Trust land, given the existing urban zoning and location within the urban growth boundary, the receiving environment including approved Cocoa Ridge building platforms, and the policy direction of the National Policy Statement for Urban Development, Policy 6, which recognises that planned urban built form may involve significant changes that may detract from amenity values appreciated by Corona Trust, but improve amenity values for future occupiers of this urban zone, and that those changes are not of themselves an adverse effect. I do not agree with Mr. Brown or Mr. Lowe that a minimum lot width requirement of 20 to 25 metres is required. The Stage 2 Cocoa Ridge subdivision has already been completed, and there are 4 lots, 27 to 30, along the boundary with the Corona Trust land as shown on the plan attached. 3 of the lots are 25, 29 and 36 metres, so it would be impossible to divide further if a 25 metre width requirement was imposed, seemingly contradicting the intent of the LDR precinct. Lot 30 is wider but heavily constrained by the building restriction area, so it would be practically unsubdividable as well. So I can just flick the page to that plan with the lot dimensions along the boundary there, which is relevant for any discussion around the proposed lot width rule. But otherwise, happy to take any questions.
Lovely, thank you. And I was just getting a copy of the MPS, just so I've got that. Okay, panel in terms of questions. Judith, do you want to?
I'm still
go
thinking
first?
about something.
You're pondering.
So if I can come,
Are you?
come back to me.
Oh, Gillian? do
I
you want
just want to pick up on pondering, because I have a question about your pond. Sorry, time of the day.
Okay, I wasn't expecting to go there, but there we go.
Did you like it?
Is the pond a stormwater management?
No, it's ornamental only.
It's ornamental. Okay. So one of the focuses for us, on the northern side has been around stormwater management, and particularly with Slope Hill. So for this area, stormwater management is
Have
through
you got
the-
a stormwater background? Is that why you're asking?
And I'm just wondering where the stormwater for this
So
is.
it's all stormwater to ground, including the road runoff from the road.
Okay.
The first 150 metres of the road, stormwater runs into the stormwater network for Queenstown Lakes District Council. The rest of it runs to on-site soakage pits.
Okay.
So smart soak things, basically big buckets under the ground that fill up and then drain away. So the ground's quite permeable where we are.
And seeing how we've already gone there, one of the discussions, several of the discussions we've been having in relation to stormwater through the week was around sites being able to deal with a 1% AUP as the minimum.
That's the rule on all our sites
And that's
too. And so each,
what was built to.
each site has, it's a little bit, so ultimately they will all have to have their own in-ground stormwater soakage for runoff from the driveways and the roof. As part of our development, some of the sites have been lucky enough we've had to install them, but it's about $5,000 to $10,000 a site to put it in, the smart soakage systems. And you'll see when we go there's some odd-looking round domes way out in the middle of nowhere, and that's what they are. They're the lids to those systems. So what was
27 to 30?
Yes, so the sites. Yeah, so for the lots 27 to 30 who've just completed, they've got their on-site stormwater is installed, and I'll show that to you.
Okay.
So just confirming what you've just said, all lots are self-contained when it comes to dealing with that?
Yes.
Thanks.
In terms of what you're proposing as well?
You mean the 37, you're talking about 37?
If you're going for more dense...
Any subdivision in the future?
Yeah.
Yes, because that'll be the rules. I'm assuming, I've read that level of detail, that'll be the new rule, won't it, Jeff? But the council's network won't be able to cope with runoff from land.
The reason I ask is, like I say, our focus has really been on the north and mainly the challenges with Slope Hill, but obviously it's something that needs to be considered in the side of the
I don't know what the technical solution there will be. So.
And it's a different catchment.
It is.
Yes.
Yeah. Just one other thing that struck me is if I was one of the proud owners of one of these new lots and I just built my house, I'd be a little bit dismayed if it was me to find that suddenly it was all being intensified further down. I thought everything was going to be large lots. Has there been engagement with the existing landowners that have bought and built on the basis that it's a large lot subdivision?
Yes, they're all aware of the plan change that's been proposed, and obviously there's uncertainty about that outcome. I mean, we've obviously been particularly concerned about what might have been an effective downzoning of these newly, so that's why the grandfathering clause is critical. I'll show you two examples up there, or three even, of homes where they've built clearly in the anticipation they might be able to subdivide.
Right.
But I think in that intensity they're looking to put one on the...
So they're future-proofing themselves?
They're future-proofing themselves, so they're effectively built on half of a 2,000 square metre section so that they might get one more house in,
in the future, sure. Thank you.
And so on that one, I have a follow-up as well. When you're talking about they're all aware, is that all the title owners were aware that this process was going on?
Well, it's part of the sales agent's disclosure to them.
There was a plan change.
There's a plan change. It's
kind of,
generally of interest to them.
I'm sure it would be.
They'll get upside, I suppose, is the short answer.
Thanks.
Gillian, any more
I've
questions?
finished.
You've finished? Judith, do you want to go?
It's for Mr. Devlin, the question.
Yes. Yeah.
So I've done my thinking now. Thank you for your patience. I just have one question, and it's around Rule 49.510. So in the notified version of the zone provisions, that rule required Area H2 to not go ahead until the bus lanes on State Highway 6 were in place.
Yes.
And I'm just interested in the logic as to why that has been changed through the planning discussions.
Can I cover that off when I come to my one, or do you want to put the planning context in it?
I appreciate the planning context.
Yes, Mr. Brown, I believe, recommended deleting that based on the advice of Mr. Shields for the council, the transport expert, I can't quite recall the exact explanation given. Mr. Brown may be able to, but...
I can.
Oh, right.
Do you want me to start? So that was part of it, our submissions, and it was picked up by Mr. Brown. I guess the logic is that we were required to stand behind a whole lot of infrastructure that was to support the northern side's development of high-density housing, etc., for a bus lane, which also seems to have been approved anyway and is going ahead. So the requirements for this area H2 now are to connect the active transport link to that bus stop. So it hasn't gone away. It's just it's a different, it's a more aligned requirement or precedent.
But it still does allow you to develop before the bus infrastructure is actually there. Under the
I think you're right. Yeah. Because there's a bus stop there already. There's a bus stop the other way out on Stalker Road.
Thank you. That was it.
Yeah.
Ian, questions for Mr. Devlin?
You say in your summary the Cocoa Ridge subdivision density and notified provisions aren't an efficient use of scarce land.
Correct.
Why do you support the grandfathering clauses? Why would we help people not intensify if that's the right thing to do?
Because my understanding is that purchasers of those lots will have different expectations. Some people will want a 2,000 square metre lot and are very happy with that. And
Zone doesn't force people to do anything though, does it?
No.
So what's the problem?
With
why do we have the grandfather clauses?
I guess to protect the people who want to keep their 2,000 square metre lot exactly as it is and not subdivide further.
No. The zone doesn't force any of them to change their lot.
Correct, yeah.
They can keep their 2,000 lot as it is without the grandfathering clauses.
Yeah, so when they go to build on their 2,000 square metre lot, the bulk and location controls that were suitable for a lot of that size apply, rather than the different bulk and location controls for our LDR precinct.
Face value, someone sympathetic to the Corona people could say it seems odd that policy 6 of the NPSUD gets invoked to say don't worry about the amenity of other people, but we have a different approach within the site that's built to make sure the amenity of people that want to make sure they've got a lifestyle that they want doesn't change. You sort of see where that question came from,
I think
face value?
Yeah, they could say that, yep. I guess, as I mentioned in my summary, I felt it was a pragmatic way to try and reflect that the lots have been subdivided under the PDP,
yes.
But yeah, some people are going to come in and subdivide them further.
Is there a time frame attached to those grandfathering clauses?
Not currently.
What if it had an expiry date that said you have a certain time frame to live the dream you've bought, but after say 3 or so years, if the correct zone for the land is something different, why you know, there's one issue of letting people build what they've bought.
There kind of is a time frame in the sense that if they subdivide and create lots smaller than 2,000,
then
LDR
so they sort of have
precinct
two
applies.
zones in one.
Almost, yeah. So
okay, very good.
The day they decide to subdivide is the day.
Why LDR? Why not medium density or high density?
Yes, well, I am on the record from my time at QLDC as supporting the Laurel Hills special housing area, which was 164 MDR units on this site. So I've always been a believer in density in this location, and yeah, low or medium could be suitable. I guess it is a long cul-de-sac at present. MDR would be better if it was, more of a networked street layout, but yeah, I think the site could also accommodate MDR.
Perhaps a question for the council.
Well, I'll worry about that. Thanks.
Yeah.
Certainly, Mr. Devlin, if we... Questions of scope in the first instance, even if we were minded to, that's not for you. But there's an interesting thought exercise I'll engage with you, which is the land currently has a zone and it's had a subdivision under that zone. The only reason it's proposed to be rezoned is because it's contributing to the resource management need that's been identified for significant mode shift and change. It's not just a rezoning for the sake of a rezoning, is it? So is there an argument that if we found that the correct zone for the land should have been medium density, but that we don't have scope to go there, actually maybe it should just stay the way it is? Because we've got council witnesses elsewhere telling us that the low density suburban zone might not support bus take up or change of travel patterns. Do you see where I'm coming from?
Yes.
Can you contribute to that at all?
Well, I think the more density in sub-area H2, the better in terms of...
Just anything better than what's there now is still even a...
Yeah, in terms of
gain.
the plan change objectives, in terms of more people getting the density to support those public transport services and things. I guess low density precinct is the easiest with what's there. MDR is harder with the the access and road width and things. I'm not fully across the details of that, but it would definitely be more difficult to sort of retrofit a MDR zone on what's there compared to a LDR precinct.
I have direct knowledge of instances where land was rezoned by a council to something completely different to what an existing covenant restricted it to. And a High Court was convinced to take the covenant off the land, even against the wishes of people who were subject to it, including because the District Council had decided a very different regime was appropriate. So I do have some sympathy with your observation about why would resource management limits be tied to a private covenant. I think in fairness, I'd have to say I'm struggling to see a resource management link to something completely separate. So I think in fairness to you, I'll record that. Policy 6, which is attached to the legal submissions very helpfully, so you'll have that there if not otherwise available to you.
It's on my one, not the legal one.
Yeah, sorry, Mr. Allen, it's your very generous bundle.
I stole it off him, don't worry.
Appendix 1 to that.
Got it? Yep.
I've had, whether it's a good thing or a bad thing, before this hearing, 8 consecutive weeks of Christchurch's Plan Change 14, and about 10 lawyers telling me what Policy 6 does and doesn't and might not say. So I want to walk through it with you.
Yep, go for it.
And I recognise this is also covered in legal submissions, and you can come back and add whatever you wish to later. As I had read Policy 6, there's a potential circle to it. We start with Clause A, and it says the planned urban built form anticipated, and this is the interesting bit, by those RMA planning documents that have given effect to this national policy statement. Doesn't say those that are proposed to do so and where a hearing is being held into that proposed plan. As I read that Clause A, it's talking about a plan change process that's been through that exercise. It creates a status quo that then goes to Clause B and says they might involve massive changes. And then you get B1 and B2, which talks about the not in themselves an adverse effect. That's how I had read it. That, unless there's been a district-wide NPS plan change that you can say has been done and exists, which would, I think, probably qualify and open this up. My reading was I didn't quite see that policy, maybe we're jumping the gun a little bit, if this plan change is the one that's doing the requisite NPSUD, or does the existing zone do that? Or how do you fill me in there, Mr.
My interpretation was that because the NPSUD applied at the time that this plan change was prepared and notified, that this is a...
so this plan change might be a qualifying NPSUD.
To give effect to the NPS.
But we go to A and it says have given effect to. It doesn't say are proposed to give effect to.
Yeah, I think the key there is the definition of RMA planning documents includes proposed plans.
Right, so a proposed plan has given effect to it by proposing something.
Yes, yeah, that was my reading of it. I was
Okay.
careful to check that definition of RMA planning documents.
And these zoning ones are operative under the proposed plan.
I don't want to ask you anything else on that. I just wanted to understand how you had read that, and that is very helpful. The last question I just want to ask is about the access to the bus. Is there a walkway through the bund to the highway? There currently is, or isn't?
Yeah, there is.
I'll show it to you tomorrow.
Okay.
Yeah.
Okay. No, thank you. I'm
Is
just
it-
reflecting your comment earlier about the cul-de-sac and why higher density might not be such a good
Yes.
idea. But
It's at the end there of the cul-de-sac. There is a link through. Yeah.
okay. Thank you, as always, Mr. Devlin.
Thank you.
Also appreciate that you are not sick and are here today.
Yeah.
Thank you. Just following up with policy 6 versus policy 49278 in the plan, which I'll let you get to. And that this is one of the policies that Mr. Giddens relies on in his evidence.
Yes, yep.
And just interested to see how you read the last part of that, and maintains the amenity values enjoyed by users of neighbouring properties, in particular privacy and access to sunlight. How you read that with policy 6?
Sure. Policy 6 is obviously the superior
Yes, yep,
planning document, so it
yep.
sort of has trumps it really. But what I said at the joint witness conferencing was that my reading of 49278 is that this is a policy to guide applications that seek to break those bulk and location controls in the LDR precinct. I didn't strike me as a policy to guide the drafting of the plan provisions. So I said to Mr. Giddens, if someone wants to come closer to the Corona Trust boundary than what the plan enables, by all means, this policy will apply. And you'll be looking at character and amenity values, etc. But I guess Mr. Giddens has viewed it in more of a directive to drafting of the provisions sort of role, as if it was almost a Chapter 3 sort of strategic direction policy, but that wasn't my reading of it. I felt it was more to deal with those consent applications that exceed provisions. Yeah.
And within the planning framework, just picking up on what you've said, is it your evidence and your opinion that that is actually how that policy fits in? It's then given effect to through, okay, we'll have buffer zones, or we'll have setbacks, or we'll have, at the margins of different areas, there's different landscape controls.
Yes, if someone wants to go outside the permitted controls for the LDR precinct, then yeah, these policies would apply, and definitely, you'd be thinking about privacy and access to sunlight if someone wants to build right on that southern boundary, for example.
Yeah. And I'm not taking anything you've said or the team said about there does need to be consideration within a terraced environment at the lower terrace. From memory, I think it might have been sought by Mr. Allen or covered in his, but from H1 to H2, there's a 6 metre setback from the top of the escarpment. I don't think from the boundary. I'm trying to remember the wording.
6 metres either side of the top of the escarpment. And yes, that was proposed by me and accepted by Mr. Brown in the early consultation. And with Mr. Devlin, I haven't taken anything you've said to be, you can't ignore what's happening down on the Corona Trust land and the potential effects. Is that a fair sort of summary? It then becomes a question of what is an appropriate setback or density or height.
Yes, I think there should be bulk and location controls in relation to the property boundary. The effect is not so much the property boundary, but the escarpment edge, that in terms of visibility overlooking it, that's where it changes. But I did say in my summary it's a little bit trickier to draft plan provisions from the edge of an escarpment, because it becomes a question of exactly where that is, you know. So, yeah, I have agreed with Mr. Brown on that point, that a setback from the cadastral boundary is easier to administer. But from an effects perspective, it's where the landform changes that, you know, the degree of visibility is determined.
And given, and we discussed it earlier, that the boundary does sort of veer back further,
yes,
do you think it should be one fixed or more nuanced by each lot? Or is it just going to be too hard to do from a planning perspective?
Yeah, because it does vary. If you have a setback from the edge of the terrace, where
I'm meaning from the boundary, sorry. So
right.
From the property boundary, as you go from, which plan is it? As you go from lot 27 to 30, certainly my reading of the different plans, the land owned by Corona Trust comes further up onto the terrace.
That's right, yep.
And so I was just wondering whether you have a blunt setback or whether you could have a more nuanced one. And it may be there's, in practice, no difference.
Yeah, I'm comfortable with a relatively blunt setback. Yeah. Just think trying to write a tricky, more nuanced rule can be difficult.
Become more hassle than it's worth.
Yeah, yeah.
And in terms of just the various effects-based ones, you're obviously, will have expert landscape evidence, but from the planning perspective, and again, this moves a bit more to density, but Mr. Lowe was asked about questions from Corona Trust, and he answered, and he gave different densities and property lengths for the options. And from a planning perspective, are you seeing, because certainly we've talked about setbacks, etc., but the density along the escarpment, are you seeing any planning concerns of potentially a change to the density on the front? Albeit from what Mr. Lowe said, it seems a very minimal change.
So there's 4 building platforms along there now. I think under a LDR precinct scenario, you potentially have 8, which I think is a reasonable number. I don't know where Corona Trust got their 15 from. I think it'd be very difficult to get that. So I come back to the objectives. The plan change for this precinct were to enable low-density residential development. If you have a 25-metre minimum width requirement for lots along there, it'll look a lot like the plan that's attached to my summary, because the lots that are already along there are, 3 of them are 25 metres or thereabouts. So I think having a 25-metre minimum width requirement sort of jeopardises the council's objectives for making this low-density residential. It almost seeks to keep it as large lot residential. Just for reference, the low-density suburban residential zone, which is being applied to the Queenstown Country Club, that in the subdivision chapter, it has a shape factor rule there of a 15 by 15 metre box.
Yes.
Yeah, so just to give you a bit of perspective, in the LDR precinct is different, but it's kind of similar to the low-density suburban residential zone, which has a 15 by 15 metre shape factor. So I prefer that as a basis for how many lots you might get along the edge there, and it's not 15. It's more like 8. So I think the council, when the panel, should stick to the low-density residential precinct as varied through Mr. Brown's, hearings version, and I don't think the 25-metre width rule is required, because I think it sort of thwarts that LDR precinct zoning.
So, sorry, I was just struggling to hear, you don't think
No.
that 25 metres required?
No.
And just before we go to that, just one other planning thing from Mr. Lowe, and sorry, working with paper, this is where I suffer, but in response to questions, no, it was in his, which one? Oh no, response to questions, I've got it right here. He also said, I'm not sure if you've got a copy of it.
I can bring it up. I didn't actually print that one, but I can bring it up quickly.
Which document, sorry?
Response to questions, Mr. Lowe.
There's discussion about accessory buildings within setbacks.
Yes.
And I forgot to talk to Mr. Brown about this earlier, but there was a question in there, and sorry, it's not numbered, page numbered, but it's the second to last page.
Right. I'll just...
And
Well, Mr. Devlin finds that. I put forward in my evidence or summary there that ancillary, I think the question was about ancillary buildings being within that setback. They're also covered in the private covenant limitations on ancillary buildings. So in terms of the Corona Trust, and in fact all the properties on the southern boundary, there's controls within that.
so that's a similar issue to the 5.5 versus 8.
Well, it's addressed as well in private covenant. It's also, I don't know, it's to some extent addressed in the low density precinct rules, but layered on top of that, it's tighter rules within the private design covenant. Any building over, I think, is 1 metre and I can't remember the square metrage size, pretty small. So anything but a garden shed.
Okay, well, we'll come back to that when we talk with you, but have you found that?
Yes, I have.
Only because there's a comment there from Mr. Lowe, I can support this request given the higher elevation of the H2 terrace.
Yes, so the concern I suspect from the question is that accessory buildings could be placed within that boundary setback.
Yes, yep.
And Mr. Lowe is also concerned about that. By the sounds of it, when he says he can support this request, he's referring to do you agree that the appropriate response is to remove the exception allowing accessory buildings relating to sub-area H2?
That's how I read it too.
Yeah.
And so my next question was, is that actually in the planning provisions? Because
I don't know if that's been in.
Because I'm not sure that.
I don't think it is.
No.
Can I read the...
what are you reading from, sorry?
This is covered in the private design covenant.
Okay, we'll do that when we come to you. I just want to see if it's in there first.
Right. Yes, I'm just going to Mr. Brown's hearings version of the provisions. Won't be a sec. No, there's no prohibition in that Rule 49.5.6 on accessory buildings in the setback. Yeah, I'd be comfortable if there were such a prohibition along that boundary. I don't think it needs to be a prohibition on all accessory buildings and all setbacks in sub-area H2, but yeah, I think along that southern boundary, yes.
Setting aside the covenant discussion. Yep.
Yes.
But as a planner, you'd be comfortable for there to be a rule if required through.
Yep.
Thank you.
The accessory buildings still do have to comply with the recession plan, but yeah, they probably could if they were small enough. So. Yes, sorry, just to clarify, when I said southern boundary, I mean lots 27 to 30?
Correct.
Yeah.
Yep. I took it as that.
Cool.
But yes, thank you. I should write that in. Where have I put your evidence? Just in your summary, and sorry, I was just wanting to check there weren't any questions I could have fairly taken from Corona and put to you, but I think that's already happened. So just within your summary, you say at page 3, and you list out reasons why you support Mr. Compton-Moen, and just want to be clear with those in the issues with Ms. Morghini's, or however you say it, with her evidence. You did not recognise both sites are she did not recognise were within the urban zone. And visual effects assessment as if the zone was a rural zone building platform application. Can you just clarify that for me?
Yes, so
apologies, there seems to be a lot of history here and a lot of applications over time, and as you read them, your mind just gets a little bit scrambled between what's proposed, and I just wanted to be clear what you were meaning there.
Yes, so in Queenstown Lakes District, probably for the last 20 odd years, any application in the rural zone has required a landscape and visual effects assessment.
Okay.
And normally that's assessing either a house, if you've got a design, or a platform. And our office does landscape and visual effects assessments all the time, and we do a lot of work in the rural zone, so I'm quite familiar with them. And the assessment that Ms. Mogini did was like that, talking about effects on landscape character and open character and stuff, and I guess I just read it and I was like, this is an urban zone. It's large lot residential is a residential zone. It's in the urban part of the PDP. And I just felt that sort of analysis wasn't really appropriate. It is appropriate in a rural zone where there's a huge amount of focus on visual effects and landscape character, but that's what it read like to me.
I was just wanting, because it's urban, so I was just wondering. And so that's where it's come from in your thinking?
Yes.
Thank you. No further questions from me. Are there any other questions from the panel coming out of anything?
Yeah, the only thing I'll do, Mr. Devlin, is to close the circle. If through whatever process we didn't land on the same reading of that policy 6 as you did, would that lead to any changes in the position you've recommended in terms of setbacks and height and density?
No, because I'm still of the view that the policy in the Ladies Mile provisions was to guide breaches of those bulk and location controls, so that it wasn't a policy to design a plan change by, and the bulk and location controls offer a basic level of protection of sunlight, amenity, privacy, that sort of thing. So no, it wouldn't change my conclusion. Thank you.
Thank you very much, Mr. Devlin.
Thanks,
Corona.
We have Mr. Dave Compton-Moen speaking to you next.
Perfect.
When you're ready.
Sounds good. Sounds very good. I'll just, Mr. Compton-Moen, just get your evidence.
Is that a speaker?
It is.
Oh, I just want to grab your evidence and then I've got everyone below.
Lovely.
Good. My name is David Compton-Moen. Paragraph 2. Since I prepared my evidence, I've attended the Landscape Expert Conferencing on the 30th of October 2023 and signed the joint witness statement the 2nd of November. I also attended the Urban Design Expert Conferencing, and that was on behalf of Glen Panel. So for the landscape it was for both, and then for Urban Design it was just for Glen Panel. And signed the joint witness statement dated 24th of November. I've also reviewed the rebuttal evidence of Mr. Skelton dated 10th of November and other expert rebuttal evidence for the Council in response to questions prepared by Ms. Mogini and Mr Giddens, dated 24th November. Having created an earlier master plan for the Ladies Mile area, I am familiar with the opportunities and challenges of this area. At a high level, I support QLDC's desire for an overall master plan for Ladies Mile. I also support the Pūtahi Ladies Mile master plan variation, including land south of the state highway, which includes a mixture of land uses with some development already approved and progressing. My opinion, for the reasons stated in my evidence, is that the visual impact of the housing development consented under RM 2.11.27.6 on lots 27 to 30 is low or less than minor when viewed from the Corona Trust land. The Te Pūtahi Ladies Mile plan variation does not change that initial assessment, as the effects of the higher density remain similar to the initial visual assessment that I performed. Furthermore, as I stated in my evidence, the proposed change in setback from 4 metres to 2 metres from the cadastral boundary will be imperceivable. I do not consider that mitigation is required to address that change over and above what we've already got in the development. Happy to take any questions.
Thank you very much. Now, questions from the panel. Gillian, would you?
No, nothing from me.
Nothing from you? Hawani?
No.
No? No? Judith?
Nope.
Nope. Ian?
Don't worry, I care. No, look, thank you, Mr. Compton-Mowen. I think, to his credit, Mr. Devlin acknowledged that all things being equal, he would have maybe supported a density greater than what's proposed on the basis of what he understands this plan change to be all about and to be trying to achieve. I know from just having seen you as a witness many times, you also often get involved in those kind of discussions of what should happen where. So do you share Mr. Devlin's view on an all things being equal footing, or is there a particular reason why you think the density sought here is in fact the greatest that would be appropriate in terms of the plan change objectives?
No, I agree with Mr. Devlin. I was involved with Laurel Hills previously in the previous one, which had a higher density.
Appreciate the depth of analysis about the magnitude of adverse effects that might result. And we're always interested in understanding the kind of adverse effects that a plan change might lead to. But the test for us is what's the most appropriate outcome. And if that includes adverse effects as part of that, then that's just what it is. So in terms of the assessment you've done, was there any non-direct adverse effects on other people factors that led you to support what you have landed on, such as some of the objectives of the plan change or benefits of more people catching a bus, as Mr. Devlin started talking about? Did you think about any of that stuff, or did you do a more constrained effects analysis only?
Yeah, on this project, it was a more constrained assessment.
Okay. And with that in mind, and you may not be able to answer this, are there any positive effects that you think are relevant to your expertise that have occurred to you that could result from allowing more density on the land than has currently been the case? Or is it just about limiting adverse effects?
No, I think there are positive effects. I think originally it's always been a concern that the sites would get underdeveloped, and so I've always been of the view that we should be trying to provide, that should be our number one position, and the council is actually providing housing, and so that anything that's designed on there should have that as its first principle, I think, and then we sort of step back from that.
Okay. To the extent that the question of whether the zone could be even more dense than it is likely to come down ultimately to a scope and legal type argument. But putting that aside and entertaining something even denser, Mr. Devlin did make a comment that, well, maybe medium density wouldn't work, it might be too hard to design, that might be a factor why a lower density is more appropriate, and didn't take it any further with him, but you're involved in designing different types of housing all the time. And while I can understand a terraced house type development starting to run into issues with lot sizes, is it fair to say that there's all sorts of types of housing that one could look to accommodate, whether it's a low density zone or a medium density zone? There's no limits on what kind of house you can go for, is there?
No, not at all. And so I think in density terms too, you've got the ability that, or the built form provisions that you've got, you can still create density within those, whether it's a individual detached standalone dwelling or you've got you've got two apartments. Or
well, that's what I had in my mind about whether a medium density zone might not necessarily lead to bigger buildings on these lots. It could just lead to more units within them, which might be a useful thing for the purpose of the plan change.
Yes.
Mm.
Yeah, I think so.
Okay, look, thank you, Mr. Compton-Mowen. That's all I have this time.
Thank you. Just similar questions, and especially without Corona Trust here, just so I'm testing it, making clear, etc., to Mr. Devlin. So, interested in that terrace edge, the interface down, and just managing effects, etc. Because again, not taking anything you've said is that effects need to be appropriately managed. It is higher up, it is looking out, and you've helpfully supplied those angles, sort of. That's a terrible word for it, no doubt it's got a proper word, but the angle diagram showing the line of sight.
Yes, yep.
But if we just start with, and you might not have seen it, with Mr. Lowe's reply to the questions from Mr. Devlin might have it up. I just want to check that you just are aligned with what Mr. Lowe was saying. Certainly he was aligned with what Mr. Devlin's bringing it to you. Thank you. So these are, there's the two scenarios that he looked at. So scenario A using a 25 metre minimum wide lot rule.
Yes.
And then B using the Cocoa Ridge consent. Noting with scenario A, Mr. Devlin, I think, picked up some comments which I'll need to check about the lot lengths and whether you could actually achieve it. But with what Mr. Devlin said, is it actually in, sorry, oh yes, there are page numbers, page 3,
yeah.
Looking at that one. Is 8 lots along there actually feasible with the different sized lot boundaries we've got, or would it be a different number? And sorry to do this off the top of your head. We'll see if Mr. Compton-Mowen can answer it.
Yeah, looking at this drawing, it would be feasible to have 8 25 metre lots. Yeah. But that goes further past.
That goes a bit further down.
Yeah, it goes past
Yep.
lot 27, doesn't it?
Yep. But just sticking with that, and what Mr. Lowe has said is, he's then looked over the page at what could be done now. And do you agree with that scenario B?
No, because I understand there's a maximum building length of 16 metres. Does that apply?
Uh-huh. Cool, thank you.
So I think the point is there are controls in there to ensure that you're not going to get a line of a wall of buildings.
Yep.
You've got yard setbacks.
Yep, and I read that, and there was discussion about that. So going back to one of the issues, there's 3 issues as I see it from Corona. One is privacy, and 2 is outlook tied with potential, I don't think it's really sunlight, but more outlook.
Yes, yep.
or visual. And then the 3rd one is more the density element to it. So looking at the density, do you see there being any meaningful difference in terms of the landscape amenity type effects from the densities that could be achieved now, or the densities of more housing up there?
No, because I just looking at 3 as well, having the 21 metre wide building length, so that couldn't actually work either on page 3. But no, I think there's enough controls in terms of your side yard setbacks. We have the height control is one aspect that I have assumed at 5.5 metres, just because of acknowledging the private covenant.
Yes, and you've got that on those angled.
Yeah, and the difficulty of that getting that off. When we did look at a previous version where we had higher densities, that was still in place, and so they were looking at dropping that terrace down, so you could achieve a two-storey building still under that height plane. I think with the escarpment itself, which has a depth of 15 metres, and the angle that it's on, and then most of the lots are actually set back. The boundary is actually set back from that edge of escarpment again. All of those factors combined, I consider that the magnitude of change is still low, or less than minor effects, even with a greater number of houses.
And could it be that, even if you're having more houses and there's a concern about density, could it be that there's a design element that could be there about sort of breaking that density? In the past, I think there was planting some form of tree.
Yeah, so we had a specimen tree at every 4.5 metres, and that was 2.5 metres in height. So realistically, that is going to break up that frontage and provide quite a green along the top of that edge. Also wary though that we weren't wanting to plant something so high that then actually blocked any views of Coronet Peak behind the dwellings. So it was always the intention to try and soften any view of the buildings rather than screen them in totality.
And again, lots of these are because Corona wasn't here, so we haven't had the benefit. But is there design elements too, like the view certainly when we were driving up there across the shot over is spectacular. So if you were going to do it, then again, not like Mr. Munro experienced in this at all, but if I was going to do it, I'd want to maximise the length of my building along to take that view. So could you have, do you have any concerns with Corona's sort of position of not quite a wall, but that sort of walled concept along, looking down but looking across? And if you do, could that be broken up through not just planting but maybe some other design thinking at the time?
I think the maximum building length and the side yard requirements are sufficient to break that up, knowing that also potentially when you see some of the houses that are developed on site there at the moment, the likelihood of them all doing a 16 metre wide dwelling I think is quite low when you just look at the nature of those. And so if more sites were then broken up smaller, I think a lot of them would still probably approach more long gable form, right, with the gable end pointing towards the view. But I think you'll notice on site too, I think all of the houses will be different.
Yes, one of the ones I sort of noticed being built was a bit more sort of like I was envisaging it, but then I noticed on the drawings provided, or some of the houses seem to be those gabled, yes, sort of long views. So,
and I think sorry if I could just add, I think a lot of those houses will actually be designed to try and probably screen views down as well. They will actually look at their landscape planting on their own property, and because they really want to capture the wider views of the mountains, and so they'll want to be blocking any sort of activity that's happening below.
Is there any, and excuse the ignorance, any practical elements that could achieve that through a design requirement or softening?
We did look at that. Yeah, we did look at that in the subdivision and felt the specimen trees were sufficient enough, noting that when you also take into account the property boundary and the edge of the escarpment, most of your views are going up over that already. It's quite a sizable, I guess, chunk of land at the top of the escarpment between the boundary and the escarpment.
Actually, I'm trying to remember, and it's gone right out of my mind as I look at it. The little sort of fence on your visuals. Sorry, this is in the appendix for the your appendix, annexure 1 maybe.
Yes.
At one stage when I was reading it, I knew what that was, and of course it's gone out. But there's the solid and then the softer tree above it.
Yes, yeah.
And I think you do say if you put a fence on the boundary, you wouldn't sort of see it in a way because of the angles.
Yes, yep, yep.
But how high is that fence? Is that sort of...
We just assumed 1 metre high.
1 metre high. So, yeah, I'm just, and this is all devil's advocate and just testing the appropriateness of the sort of fronting and how to soften or not. So a person would look sort of, potentially could look over that height.
Yes.
Yep.
Yep.
Okay.
Noting that fence on that isn't actually on the site. Like it is on some of the...
Yes, it's site boundaries sort of.
Yeah, so it's still on the
Yep.
Corona Trust property.
That's right, and there's a discussion of hedges and different things. Maybe it's a hedge actually, sorry, rather than a fence. But the interest with that is whether, are the trees still in the proposed rule provisions or a softening element?
No, the requirement, consent notice requirement on the subdivision, that if, and you know, the subdivision's been built, but they haven't, there's been no attempt to replicate them through a district plan.
And so if this plan came along and something was built under it, would the, sorry, I'm getting awfully confused with all the different things, but would the, if consent's granted, people could act in accordance with that consent, but if they wanted the new density, they'd need to go into the new provisions, and there wouldn't be that sort of softening requirement?
Correct. One provision in the LDR precinct requiring a specimen tree every 4.5.
Yeah, 4.5 metres.
Yeah. Would that be something that could soften, it's obviously been thought of before.
Yes.
If this was to go ahead, would help soften that boundary? And do you think it's required or not?
Yes and yes, because on our original assessment we relied on that planting.
So that might be something just to think about and talk to Mr. Brown about. And then again, the 2 metres versus the 4 metres, obviously there's a 20 odd metre one as well, but the 2 versus the 4, which is between you and Mr. Lowe,
yes,
and etc. Again, I think what I took from your evidence is, given the angle diagrams,
yep,
basically there's no point with that difference. 2 or 4, the effects are going to be the same in your opinion.
yes.
If, however, we were minded to go to the 4, do you think that would be some, even if it's minor lessening, or it's just inconsequential? I'm just interested in the difference you see. I know you support the 2, but the difference in your opinion between the 2 and the 4.
I think it's inconsequential. I think just the width of the escarpment and then the distance to some of these buildings, I don't think it'll be noticeable whether it's 2 or 4 metres.
And then driving around, and again, I've only driven around there once, but with Shotover and Lake Hayes, there seems to be a number of houses close to at various points the escarpment.
Yes, yep.
Are you familiar with the sort of wider area?
Yes, yeah. So,
do you know what sort of distances they are back? Just from that might be too technical, but some of them seem to my mind to be quite close, but potentially when you're there, they're actually sort of 3.5 to whatever you're already proposing back.
Yeah, I did. I can't remember off the top of my head. I know it does vary along that southern boundary. So parts of Cocoa Ridge do come to the boundaries come down the escarpment and onto the edge of Max's Way. But then as we come around to lots 27 to 30, the boundary heads up the escarpment, and then the boundary's at the top.
Yep.
But within, I'd have to measure within Shotover country in terms of their setbacks.
It was just a question to help me sort of think what it might look like potentially if there was a reference.
Yep.
But that's fair. With the setbacks and keeping with it, because we're talking, and I can absolutely see the benefit of taking the setback from the actual property boundary.
Yep.
You avoid a whole heap of problems about where's the escarpment edge and people reclaiming and pushing it out and then creeping up.
Yep.
But obviously at the eastern end where the boundary's right on the escarpment,
yep.
If we do use a uniform setback, rather than I asked Mr. Devlin about a modified, we're going to be a lot closer to the escarpment than at the other end.
Yes.
From an effects point of view, and your opinion as to the potential effects, should it actually be different like that, or should there be some consistency of setback to ensure there's not that?
That lot 27 is probably the one where the effects are the greatest, but I still think they're less than minor. So in that respect, then I don't think there's a need to have a difference for lot 27 compared to lot 30.
And if you were at lot 27 and you were 2 metres from the boundary, and the boundary, setting aside geotech and everything, and the boundary was pretty much on the edge, let's just assume for now it's the escarpment.
Yes.
Could you have like a softening of planting trees there, or would you actually need your building back a bit to let the tree sort of, because we've talked about the softening.
Yes, yeah.
And I'm just not sure how you'd actually fit that in if you've got such a small setback, but maybe it's fine.
It should be fine. The plants, there's a number of poplar trees that are already growing along the top edge of the escarpment, and some recently planted pittosporums. They're all doing really well.
Would you want a pittosporum 2 metres
Well,
from your front window looking out?
No,
over
I
that
think
remarkable view?
you'd trim it, and at a hedge it, obviously you'd maintain that.
But would that give the softening you're looking for? Because I saw the softening as vertical as well as a horizontal break.
Yeah, yes.
It gave a vertical.
So it is both. But yeah, a pittosporum hedge would soften views from below, definitely, and then the vertical trees would actually break up that.
Right, yeah, I was thinking more of
elevation.
the vertical tree.
Yes.
Would you have space to fit that in at those 27, at lot 27 area where the boundary's closer?
Yeah, it'd be right on the boundary.
And right on the escarpment edge,
Edge,
potentially?
Yep.
And do you see any issues with that?
No, but it might. Whoever designs their house then potentially would work around that aspect.
And the council's 4 metre, would that be easier at that location for that softening?
in that location would give the tree more breathing space. Yes.
Thank you. I'll just check though before I finish as to whether, oh, sorry, do you have?
No, it's like,
Whether I've got any more questions or whether there's any follow-ups, especially mainly because Corona isn't here, and I'm just wanting to make sure we're being fair to the process and putting questions to you so that we get the material. Sorry, there's a lot of paper of the different things. I've actually got no more questions for Mr. Compton-Mohan. Does anyone else? No. No. Thank you.
I was,
All done. Oh, no,
I was
there's...
just asking Mr. Compton-Mohan to develop a couple of his answers to you, because there's things that will become obvious to you at the site visit tomorrow. I just wonder if he could just talk to those two things.
yeah. So the one is the no vehicle access on the escarpment, or from that side.
So this is relevant to Mr. Brown's evidence, where he has told the panel that there's a possibility in the future of houses coming on to the escarpment, but that geotech's unknown.
Oh, onto that face above
Yes,
Max's.
and so
I think that's been...
That's been
covered.
solved, has it?
No, you still okay?
So that was just one topic that Mr. Compton-Mohan can assist the panel
Perfect.
with, and you can
Thank
see
you.
that in the site visit tomorrow.
Yeah. So, and that's where the down the
It just goes down into that boundary tracks down into.
onto Max's
Yeah,
Way.
that's right.
I think you've got.
Yeah.
Yeah. Well, because you've got a limit on.
So,
And you're going to see it tomorrow on the site
Yeah,
visit,
yeah.
so.
just so you'd be talking about building on 2, that sort of number 2 on Mr. Compton-Mohan's annexure A in his sections. Sorry, rather than angles, I should have called them section diagrams. Cross sections, there we go.
I think in terms of those cross sections, it's not an issue. Obviously, it's just where.
Or is it actually further to the east where it
Yes,
drops
further,
down?
further to the east.
Way further to the east.
So it's not, yes, okay, now.
Yeah. Yeah.
So that was why, sorry, I was getting muddled with the maxes.
No.
So there was discussion about the eastern end where the boundary comes down to Max's Way. Yeah.
Yes. Yeah. So do they?
So we're talking about the boundary, I think we're talking about the boundary
Yeah.
between lots 9 and 12, so along that.
Yeah.
Those, so most of those boundaries is the actual escarpment dropping down to Max's Way.
Yep.
And I think you want to make some comment about that, is that right?
Oh yeah. If for those properties, and if they do have access onto Max's Way in terms of vehicle access. Oh,
They don't.
they don't.
Yeah,
they don't. So
don't.
yeah, that's the point. So
That's
it
the
actually
point.
provides that setback on that frontage. If they did have access, which they don't, but if they did, you could potentially have a garage, and then you'd have your living upstairs, which would bring houses closer to that part of Shiraka country.
Okay.
Yeah.
But maybe that can be explored more in your
the site
submissions.
visit, Yeah.
Yeah.
I think,
And you can step us through it, and then we can
Yeah.
see at the site visit, just because we don't want to be step through it per se at the site visit, we need that now,
Yes.
and then we can see it and be told, look at this because of this issue.
And essentially what we're saying is that possibility will never arise because it's not feasible, not workable, not practical, and you'll see that it's very obvious when you're on the site tomorrow. Yeah. And then, so that was the only other point that we wanted to develop from Mr. Cox.
Thank you. Sorry for the confusion. I was at the wrong end of the subject.
I was too.
Now look, I'm just conscious it's 4 to 5. I wonder if...
Oh, we've got you in the morning too, haven't we,
Yes,
with time?
yes.
So
Yeah.
we're actually good for time.
Yep. So I wonder if we just pick up with Mr. Allen tomorrow morning and...
I'll just...
I'd like to ask you to reflect on one thing overnight that I want to ask you tomorrow.
Mm-hmm.
Do you have the original submission of your client with you?
Yes, I do. Just one moment, I can turn to that.
It speaks to this question I put to two of your witnesses about
Yes.
the zone, and there's one particular aspect of the submission I want to ask you to think about.
Yes.
Now, the submission covers a lot of pages, and I'm looking at the PDF of it, so I can't tell you which page, so we're just going to have to go through it from the start together so we land on it. So we have the first page,
Yes.
and that ends with the submission on non-complying activity status. We then have the next page, which finishes with the words, "This provision is supported in its current form." Then we have the next page, which talks about mixture of residential densities. Then it's the next page I'd like you to think about. And the provision that says Ladies Mile, and the words, "My submission is, we support a specific zone for the Ladies Mile area. We support the zone providing for land use that's suited to an urban environment. We support this zone providing for medium density housing." And I'd like to know what that means in the context of submissions that often have what a submitter would really like,
Yes.
but also a range of other things that might be acceptable.
And possible.
And so if you could just reflect on that and give me a very clear steer of what you think the scope of this submission is or isn't.
Thank you. Yes.
Okay, thank you. That was all, thanks.
Actually, just on that, that's reminded me above it, I've got, with the residential visitor accommodation
Yes.
and grandfathering,
Yes.
and we've only got Mr. Devlin today, so just I'm trying to remember if is there an exclusion within precinct H2 now for RVA? I know in the medium density there's RVA, in the high density there's RVA. I'm trying to remember.
It was struck out.
If it's come back in, though.
Oh, has it come back in?
We're not aware of it coming back in.
Sorry, Mr. Brown, to do this. I know it's in for high commercial, high density, and I think medium density.
No, it's not there for medium density.
Not there for, it's only.
And there's limited opportunity in the high density precinct.
Perfect. Okay. Excellent.
Does that answer it for the low density?
It's Rule 49 4.5.
2.5.
It's residential.
Struck out, isn't it?
No, residential visitor accommodations non-complying.
49.
Non-compliant. Yep. Yep.
Except for the
visitor,
grandfathering
yeah.
in area H2.
Are we mixing residential flats with visitor?
So the grandfathering has been captured and brought into H2.
For a number of things, including the residential visitor accommodation.
Yeah, it was, I missed the residential when I was thinking of the earlier with the accessory sort of building type things.
Right.
Yep. Okay, thank you.
Thank you.
Thank you. We'll see you in the morning.
Thank you very much.
Thank you.
Should we ask if Dave needs to be in the morning?
No, he doesn't need to be here.
Right.
Oh.